Welcome to Defense Diaries for day 14, actually the charging conference, because the defense yesterday rested without putting on one witness. How's that going to work out for Kouri? Only time will tell. Let's get into it here on Defense Diaries. Hello, beautiful humans, and welcome to Defense Diaries. I'm your host, Bob Mata, and as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. It's Friday, March 13th.
Indeed. Happy Friday.
Happy Friday. Technically day 14, even though the jury is not in today for our jury instructions. But before we hop in, babe, let's just recap some of what we have been through in the past several days.
I mean,
I just have to go back to, and I might as well just share the clip because I know we all remember it. It was so exciting.
I'm dying to know. Wait, you clipped some particular areas that you wanted to revisit? Is that what you're saying to me? Wow.
Who's defense counsel's first witness?
Quick,
Yeah.
we have options.
Understood.
Couple of options. We just spent an hour and a half discussing those options and how we want to be. You can hear something. Watch. Listen. Oh, I'm not doing that.
You don't want
I already did that. That's what she said. I already did that.
Your Honor, actually, at this time, the defense intends to arrest.
Wow.
We should probably do that in front of the jury, yes.
Right?
So let's just revisit this. We do remember they were in like an hour and a half break.
Coming right out of the break. This is right out of the break.
And I mean, when she tells the judge, "Oh, we're ready," like the first time here. Let's see.
Oh yeah, we're ready.
Oh yeah. Mr. Bloodworth, would you? Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's
Ready to go.
defense counsel?
Ready to go. And then the look between the attorneys when he calls them out and says, "Who is the first witness?" This look.
Counsel's first witness.
Huh?
There's a pause as they look at each other. All right, who's going to blink first? What are we going to say? How are we going to answer this question? What's he doing over here? He seems like
Ramos?
Yeah, like
yeah.
What are they doing?
More importantly, what is their client like? This is so bizarre in so many ways because Allie and I were talking about this morning. We're like, what was the end goal? Like what are they trying to accomplish by pretending like they're putting on a case for about 30 seconds? And then the judge says, "Okay, well, who are you going to call?"
I think this is what I've come up with. They wanted for some reason thought the shock and awe of it all was helpful to them. Like, wow, they're so sure of their case. They're not even putting on
shock and awe to whom?
The people in the gallery.
People.
Like the
Bloodworth
face, like
you thought Bloodworth was going to crumple to the floor. They're actually putting on a case. Like, no, I reject all of that. None of it makes any sense.
And what
I don't know.
Be?
I cannot.
I wish we could zoom in on this mirror back here. I'm just seeing this. How you can
see the judge's face.
Yeah, I wish we could zoom in to see. Did he really have like any because he didn't blink an eye when it happened.
He's thrilled. He's
Of
like, I'm getting
course.
the case off my docket. Take
I
care
mean,
now.
I'm sure that they decided that they could only, like putting on a case was not going to help them. They were better off to do nothing because if they put on a case that was perceived weak, or didn't play out the way they wanted to, or, and then they're coming back with this strong, I don't know what the rebuttal case would be, you know. But
Yeah.
at this point in time where they're staring at each other like that, they sure as shit already know they're not calling anybody.
They have to because they
They-
never talked to Kouri before she says she's resting here at the table.
Right. To be like, change the plans.
Right.
We just told the judge we're ready. So if we're going to accept that at face value, then her client thought oh, yeah, we're ready. Not only that, her client thought they had a couple of options.
Mm.
And then they just said, we rest. So
I just
then
don't
what
get
is
it.
the answer, babe?
I don't
What is
know.
the answer?
I cannot think of any viable because the jury's not in the room. So it ain't that. It's just the judge. And I mean, like, are they wanting to give blood work like 15, 20 seconds of anxiety that he's got to prepare mentally for the state's or the defense case in chief? Was that it? Like, you know what? Let's stick the screwdriver and blood works back just for 15 seconds so that he thinks we're going to put on a case, and then we'll say, just kidding. I don't know, dude. I don't know.
The only answer is, for some reason, whatever it might be, the two of them, the two female lawyers, because this looks like their little song and dance right here, their little show right now, was like, it's going to have some kind of impact if we don't tell anyone in that courtroom that we are resting until we tell the jury. It's the only thing I can think of, because there is no way, shape, or form that Kouri walked into that courtroom thinking they were putting on a defense.
No way.
And then they just did not
That's
happen.
what I'm saying, without consulting her
Right.
at the table.
Not
So
a chance.
They clearly knew what the game plan was.
By the time they were sitting there saying they're ready, they knew the game plan.
Yeah.
I just don't know what what the point was,
It's crazy. It's crazy.
And one of the other things that I want to talk about is just like, yesterday I was still in shock from the whole there was this March 4th phone call where, so it's like in my mind, I think there's a damn good chance that she did this. But as a juror, not if I were a juror or as a lawyer, I feel like the state didn't make that there's reasonable doubt that the state hasn't reached their burden. But I still 100% think this jury, if I was, what's that poly whatever thing?
What?
I don't know, where you can vote on verdicts.
Oh, Poly Market.
Yeah, let's hop on that poly market and vote guilty. That's what I think is going to happen. But as we reflect back, I was a little surprised that they didn't at least call a medical expert, and they must have thought that their medical expert was going to be as
To testify as to what?
that the uh, that it couldn't have gotten there from a drink because there wasn't enough drink. I don't know, maybe they established all that on cross-examination. There wasn't enough alcohol in his system he would have had to drink like a sloppy.
Well, I think that they should have done two things. I think they should have put some kind of expert / cop that would have been able to get on the stand and testify that at that point in time in our country, that the amount of fentanyl deaths around the country that had, specifically in illicit street drugs, was massive. I mean, it was so massive that the feds changed the law. Like they made a law that if you're knowingly dealing fentanyl and somebody dies from it, you know what I mean? It's like it was that kind of deal. So like, I think they needed to put it out there, because if you're going to try to sell this concept, which I think they should do, that maybe, just maybe, Eric asked one of his, one of the guys that does work for him, one of his laborers, yo, hey man, you have a oxy, you could kick me, like my back's hurting me. And dude gives him a bad pill. Because what people are not understanding about the fentanyl is that five times what would normally kill him is like a nanogram is like a grain of salt.
I'm just not sure about that when it comes to those pills. You're telling me that you have a pill and there's just why a whole pill for a nanogram of I don't know.
Well, because how are you giving somebody a grain of salt? Like, here's a bag of a grain of salt. Like whatever the filler is in all pills. Like, I have to assume that whatever, and if we have any pharmaceutical people in the chat, maybe let us know. Like, I think there's a blend, when you have Pressies, which are pills, right? It's like if you're buying like Pressies, like Molly or MDMA Pressies, like I'm assuming that's not all MDMA, that it's mixed with something that binds together so that you can make a pill.
Right.
So I don't know. To me, it's important. It would have been important to put it out there that poison pills were everywhere on the black market drug streets at that point in time in 2022. That like it's not some crazy concept to think that you would have accidentally run into some bad pills, because it was very prevalent.
Right.
I
I think they got that. I think they
maybe
got that from remember the medical examiner testified she was doing a lot of
Yeah.
fentanyl overdose.
I mean,
stuff.
enough for them to argue it.
Right. And I think that in retrospect, I wish that we heard the pretrial stuff on the gifts. And I'm going with gifts just because I do believe since it's graphic something, it's a G sound. That's where I'm sticking.
I've always been a gift guy.
Right.
Always. No,
I don't know
nobody's
which
ever
one.
changing my mind. I don't give a shit what anybody says.
But in
It'll
any
always
event,
be gift to me.
I think how the state was able to put that on when there was zero evidence about where it came from time-wise, you know, but I do think that the defense did enough, like you said, on the cross to show this could have just been a woman going back and looking at the last text.
Hey, people saying your mic's too low.
Oh, well, I'm gonna click to auto adjust. What are you on?
79. Somebody said I was
Let's
cranked up, and I checked, and I was at like,
let's just
for
go to
some reason, I
auto.
was at
Let's both go
144.
to auto and see how that works with court today.
It's going to be loud.
Well, we'll see how it works.
All right.
If it
Okay.
does, then we'll adjust downward later.
Okay.
That she could have just been looking back at her texts between her and her husband, which overlapped in time when she's looking at those pictures with whatever other pictures that were sent in relation to the house. I mean, I am never believing, even if she killed him, that she's sending anybody a meme of her wiping her tears with money. Like, no, and I don't think that the state proved that at all. Like, that's
It's not a matter of oxys being cut with fentanyl. What was happening back then is that they were pawning off fake oxys. It wasn't an oxy cut with fentanyl. It was a pill purporting to be an oxy that wasn't an oxy.
There is a ton of like established cases of people thinking they were getting oxys, trying to get oxys and ending up with fentanyl. That's
right.
A real
but
thing.
What I'm saying is it's not an oxy cut with, it's a imposter oxy. So there is no oxycodone in there. But it appears the way that they do the markings on the pill, it looks exactly like what oxys look like. That's the whole thing here. So I don't know. Like, I don't know what else the chat was saying, but Jody was like, what in the hell are y'all talking about? So that, I mean, because the imposter pills out there were, it's just like, I mean, that that's a thing. It's still a thing. It was a huge thing back then, but I don't know. All right, I'm going to pull up the court. They have not started yet, so
real quick. So DEA public safety alert. The DEA laboratory testing reveals that 6 out of 10 fentanyl-laced fake prescription pills now contain a potentially lethal dose of fentanyl. And they say these pills are being mass produced by the Sinaloa, how do you say that? Sinaloa cartel, which is where he was in Mexico, right? Sinaloa.
I don't
Sounds
know.
it
It
can't
was
be.
Sonora. It might have been Sonora.
Oh, Sonora.
Maybe. I don't know though.
Okay.
I'm not dying on that hill.
Okay, so then it says last year, and I guess I should see when this. I think this was a 2022. Oh, doesn't say, but it does say pills analyzed in 2022. So it says last year, the DEA issued a public safety alert on widespread drug trafficking of fentanyl-laced fake prescription pills in American communities. These pills are largely made by 2 Mexican drug cartels, to look identical to real prescription medications, including OxyContin, Percocet, Xanax, and they are often deadly. So they are saying that in these pills, the DEA's national operational surge to target trafficking of fentanyl-laced fake prescription pills seized over 10.2 million fake pills in all 50 states. Through its One Pill Can Kill campaign, the DEA is working to alert Americans to the public dangers of fake prescription pills. So there you go. Then it says just 2 milligrams of fentanyl. The smaller amount fits into the tip of a pencil is considered a potentially deadly dose. It is highly addictive synthetic opioid that is 50 times more potent than heroin, 100 times more potent than morphine. And there you have it. Well, let's discuss. Is there anything else you want to discuss before? Because I like blooping time, especially with jury instructions. So let's see what the people are saying. Let's get another poll going. I need a poll on the attempted murder, which I don't think that they proved shit with that sandwich. And I know some of you were saying this in chat, and I think Bob and I were not clear before that the EpiPen is the son's. You know, that was something that the defense looked like they got egg on their face by pushing the EpiPen. And did you find out about his allergies? And then we find out the EpiPens were the kid's EpiPens, not his.
EpiPens. I'm trying to set up a grift. What should I do for today? Grift goal.
just set a goal, and then Bob will do something funny.
Ian always sets goals where he just tells a little story.
Here's a little story I'd like to tell
about 3 bad brothers you know so well. It started way back in history.
With?
Hold on, I'm thinking here.
You got to say with once you get there. It started way back in history. All right, Mike D.
Hold on, I'm thinking of a grift. We've already got 3 sticker giveaways.
See why we need zip up sweatshirts for women. I'm hot. I'm cold.
Oh yeah.
Cold. I'm hot.
Oh yeah. Oh yeah. Dang. What's a good goal?
Let's see what the people think.
What's a good goal?
Here's a little story.
I can't think of a good goal.
Bob could probably do all the lyrics.
Oh yeah.
We could make Bob sing a Beastie Boys thing. Oh, let's make Bob sing a song.
Hey man, you know how I am about that kind of shit.
He doesn't like to perform. He's not a performing monkey. He doesn't like to perform on man.
Oh, Kyle wants me to put the hat on. Do you remember the hat I wore for the dramatic reading? Oh, dramatic reading was something else. It was
again, I think another time I tried to just kill your thunder.
One
time I didn't want the hat.
Oh yeah. Oh yeah, Tony's pup. So sweet. Such a sweet, sweet pup. Ah, man. Let me think. See, the wheel's always easy. Giving away
So
something.
I just want to say, to me, as just a human being, not a lawyer, not a juror, but as a watcher of juries, of it, there's too many coincidences here with that March 4th call that makes me say she did it. But the evidence presented at trial, I'm like, she probably did it, and that's not guilty. You know,
Wait, what did you say? I wanted to hear. I was typing a goal.
as like a watcher of trials and knowing about that March 4th, 2022 jail call, I just think it's too coincidental. She bought pills that now the drug dealer is tied directly to fentanyl before anyone knows, before there's any reason for anyone to be lying about fentanyl, and then he dies of fentanyl and no one finds these pills, and she needed it for some investor, and I don't give a shit, the fucking hush puppy. That's what I'm saying. The poor dog and the hush puppy.
I want to know about
Now, do I think it's possible? Again, I said this before, that she was trying to knock him out so she could
that's a good idea.
enjoy her. And Bob says she didn't really love the guy. She didn't really even want to have
Babe,
Valentine's Day with
I
him.
just want you to know what the goal is. So Allie will perform Dusty Springfield, Son of a Preacher Man.
No, it's
I
not
put it
happening.
out there. It's out there.
No, it's not happening.
There's no backing out of it. You're on the books.
It's absolutely
It's
not
in the
happening.
books. It's in the book. Actually, I thought of a better one.
Oh,
Actually,
thank
this is
God.
outside. All right, so I'm gonna
Got to
end
catch
that
me
one.
at a bar one day.
Yeah, I'm gonna end that one, and then I'm gonna do a new one. All right, so this is gonna be great. We love this. We love this. For closing arguments on Monday, the winner of a wheel spin that is going to come on with us for 15 minutes during closing arguments live.
Okay. That's a good one.
That's a good.
You
I
better
always
make
love that.
You better make it high then.
Hi.
But the people know that we are suckers, and we're not going to let their donos go in vain.
You're so vain. All right, got it.
I'll tell you a story about that song.
Dang it, how do I end this damn goal? Bobby, I can't end the damn goal. I don't know how to do it. Oh, there's the guy. So sweet. I keep going over here saying remove goal. Remove this goal. Okay, yes. Yes. Okay. Remove the goal. All right, there we go. Okay. Winner of wheel spin will come on Mondays live. Oh yeah.
No, history. Allie does not have to sing. We've got a new goal.
What? Chicken.
I did sing. I said, here's a little story I'd like to tell. That's what I did.
All right, and just so I know there's probably people out there like, I don't want to come on a live. I don't want my camera. I don't want to. I mean, if you're insistent, you can do
Turn
what
off your
Allie's
camera.
doing right there. You can do that.
I'm not doing it anymore. It's old.
I know, but I'm still on YouTube, so it's like it's always a little bit behind.
That's old news, babe.
Yeah. YouTube is
so, but I also really need to get this guy. We have to look for him. I don't know why I haven't done it yet. I'm being lazy. Whatever his name is.
Chuck Norris.
Chuck Norris. Yes.
Yeah.
I need to know, because that is shocking as well, but the prosecution's making it seem like it was so outlandish. The judge is making it seem like it was the most outlandish thing he has ever heard. But we didn't hear any of it.
Oh,
Didn't
yeah.
hear any of it.
Oh, yeah. All right. So I put the goal up. All right. So don't be afraid. Don't be afraid. Every time we've had people on, we did it during Karen Reed. It was fabulous.
Fabulous.
Absolutely fabulous. We love having you
Fabulous.
guys on. It's great to be able to speak in real words with one of our beautiful family members. So don't be shy. And like I said, if you're insistent, you don't want to use your camera, don't use your camera.
Yeah.
But you're all beautiful humans. So nobody out there should be like, oh, I don't want to be seen by people. Okay.
I mean,
So
I'd
then
rather
you
not be
might-
seen by people.
Oh yeah.
Luckily for me, I've got a real bright light,
Oh yeah.
or I'd be out. Tweak my appearance, or I'd be like, no, babe, I'm not doing it. I'll do it with my camera off. I can barely do it with the camera on now. Especially when I have to see myself on the big screen. Like I'm ready for us to be little again.
Oh yeah. All right.
Iceman says, very unpopular opinion, but I would have an argument that Carmen didn't even get drugs for Kouri.
Oh yeah.
I don't believe Carmen and not solid on payment. I mean, that second one, I don't know why the state's running from the second one, the fourth one, sorry, the one after, because they were like, well, didn't she just pay her for actual work that she did? You know, like, isn't it almost better that something caused her to, unless they have switched gears to she was purchasing it for her husband who was addicted.
Yeah. Yeah. I mean, to me, this entire closing argument is going to be pounding home the concept of beyond a reasonable doubt, pounding home the concept of it is the state's burden entirely. We do not have to prove anything. I'm going to be honest. I was disappointed in seeing some law tubers kind of like calling the defense attorneys out because they did an opening but decided not to put any evidence on. I mean, that happens.
It does, but you're not supposed to make promises. That looks very bad for you. If you
I mean,
make
what are you
promises
gonna
you can't
do?
keep.
So what? If you decide that the state hasn't met its
Did they
burden-
make promises? I can't remember.
I mean, they made some promises.
Well, that looks bad for you. You don't make promises that you can't keep. You know? But yeah, things change and it has to happen. But what if the way that they pulled this, like,
What is
we're
the
gonna
other option? Not doing an opening? Like
No,
holding
no.
everything back on the potential that you're not going to put on a case in chief? Bullshit.
No, but you focus on what you know is gonna you
Look,
focus
we know we said some things during opening. However, when the state rested, we felt strongly that they had not met their burden, which is a very high burden. Like, you're allowed to say that kind of shit.
So here's the thing though. What about the possibility? I was just thinking about how they like did that little weird song and dance that we still don't know why they did. Pretended they were about to call a witness. Yeah, I got a couple of them in the hall here. Got them all lined up, ready to go. Ready to go. If they did the same thing with closing, I don't think they can here because I think there's a lot of things they need to tie up. But in theory, if they were to let the prosecution go with like their initial, we're holding all the good shit back in our closing until our rebuttal closing, and then said, Your Honor, we're waiving closing. And then the prosecution couldn't get up and put in all the shit that they held back. But I guess I'll have to see their closing because they may be like, the way this defense rolls, they could catch us with our pants down at closing.
Pants down.
But I mean, do you think in this case, let's just assume if the prosecution got up and did like a very bare bones closing, holding all the good, juicy stuff for the rebuttal, could the defense, if people are feeling the state hasn't met their burden, could they get away with just saying, we waive our closing?
Who, the defense?
Yeah. And then the prosecution doesn't get to get back up.
Well, do we know for a fact that they do rebuttal closings in
Yeah,
Utah?
I did check. Utah has the normal procedure.
Yeah, because what trial did we just watch where the state didn't get a second bite at the closing apple?
They just went second. It might have been Massachusetts. I can't remember.
Yeah, it was. I thought it was the last trial we streamed.
Well, that was
Was that
Colin. Well,
Gray?
you weren't on for that
I wasn't
closing.
on for that.
But yeah, it probably wasn't Reed, right? They had a
Oh, and just so y'all know, obviously PayPal's, Venmos, Cash Apps, all those count towards the goal. So don't be thrown off by the YouTube goal in terms of the number, because we obviously count everybody that donos through those other avenues. And frankly, we like it better because YouTube doesn't get their cut. So yeah, I don't know, man. Dude, that would be insane.
yeah.
That would be so ballsy.
Yeah.
But
And
like, I mean, if
everybody's saying
it's not in evidence, like, what are you worried about if you're the defense? I mean, the case is what the case is. I mean, we all know, everyone knows what the state's theory on this case is. It's not a mystery to anybody, right? So he's going to be making argument. Because, like, let me ask you this. Like, I have developed a way that I think that I would have handled the walk the dog if we were defending Kouri Richins. How would you, an argument, how would you handle the walk the dog letter? What would you say?
we know what they're going to say. You can pause it when they start because we will be happy to have some blooping time. But I have to think about it because there are a couple of things in
What do you think they're going to say? That it was a part of a 65-page book?
No, that there's so many facts in here that are true. What does it matter that she's trying to defend herself and trying to get people on the same line of thinking as her and reminding them of things to say, because it doesn't seem like what she was doing was asking them to lie.
You have to make the other part of the argument, though, because the state is arguing that it's proof of consciousness of guilt. You have to make the argument it's quite the opposite. This is an innocent woman who sees the writing on the wall. Her attorneys have been talking to her about what the evidence is that the state's putting forward in terms of this theory they have. Do you expect her to sit idly by and get convicted of a crime she didn't commit? You know what I mean? Like, you have to frame it that way.
I think framing it that way makes more sense than saying it was a novel. It's too
well. I've never
specific.
seen a novel. That's fucking stupid.
It's yeah. You know, and I still think that even with the way, you know, like there's, I mean, it's an issue. There's language in there that's an issue, and I think what you're saying is probably, you know, the best thing that you can say, and they'll probably get up and rebuttal and be like, so what the defense is telling you is that it's okay to suborn perjury, but the judge said it wasn't witness not intimidation, tampering.
Yeah.
So it wasn't suborning perjury. So they can't really make that argument, you know.
Well, it never made it to anybody. Had she stuck it on the window, and when Lisa Darden was in there, her mom, and she read it, and then Lisa Darden goes to Ronnie and says, "Hey, your sister needs you to come up with some shit." Because, like, once the thing is out there in terms of the state puts it on, you can't then bring Ronnie on talking about this football. I was watching a game with Eric, and he brought up going down to Mexico to score some fent.
It was a quick, you know, 2-minute discussion during a football game.
Right, like verbatim what was.
And again, I think what hurts her with trying to, if the defense is going to say the evidence suggests it just as easily she could have been securing drugs at the request of her husband. Again, and I said it on the last live, like, so much insistence that he never did drugs to everyone in her life, not just authorities, not just insurance companies, you know. And I missed the whole data analyst. Was the evidence that she was deleting these messages? That she was actually deleting stuff? Because and did they ever explain why they didn't have the ability, like every other extraction report says deleted, even if it couldn't be recovered? It'd be like a blank space deleted. Are you muted or they don't have the sound on?
I don't have the sound on.
So
State of Utah versus Kouri
pause it real
Richins.
quick.
He's excited.
Counsel for the state.
He's like, oh my God, I can't believe this trial's over.
Let's just do a couple of these supers. Give us some blooping time because I promise you're going to want to listen to this in 1.25. Frisvold says, I have a tendency to believe the jury will automatically assume guilt if the defendant does not put on a case. Horrifying concept, but we appreciate your honesty. And that's the fear. And
Wait,
that's
like,
why.
are you suggesting that she's not completely right? Because
she shouldn't be.
Right. She says I have a tendency to believe that the jury, she is right, though. That's not how she's saying she is.
I get it, but I'm saying it shouldn't be accurate.
But
the whole system is set up right. But that's why Bob and I really drill this during voir dire. Like really go at them with it. Are you gonna have like if they put on no case in the back of your mind, are you gonna be like, now, like we really stick it to them,
shady.
And we have had jurors who said, well, I think I would kind of, but yeah, I think in the back of my mind, I would kind of.
That's why I'm saying.
But that's what you got to deal with it
in closing. So this
but in voir dire.
Okay, but you really need to deal with it in closing because in voir dire, you're only able to accomplish so much.
Right.
And you never know if jurors are being completely honest. You have to address it in closing. So in a case like this, where there's not incredibly powerful circumstantial evidence as to the ag murder, and especially as to the attempt murder.
Right. So
but here, my point, wait, why do I need to refresh, Pokey? What's going on?
We paused it.
Huh? Oh yeah, I paused it.
Yeah, I want some blooping time.
We're getting blooping time because it's a charging
conference.
Like nobody needs to be overly concerned about us being on time for the charging conference because it's slow. We want to have some blooping time. Trust us.
I was hoping we could listen to it at 1.25.
Woo! But here's the thing: when you have a close case, because I am of the camp that a vast majority of times that closings don't matter, that people have already reached their opinion, their conclusion on a case before closings. And that's in cases where I think there's strong evidence. In a case like this, where it is wholly circumstantial, which isn't a death knell, because most cases are circumstantial, and you can have incredibly powerful circumstantial cases. This is a story that is magnificent. It's a phenomenal theory. It gives you motive all day long. However, they didn't prove to me that, number one, Kouri asked for fentanyl and got fentanyl, and number two, that it was her intent to kill Eric. They didn't prove it. They gave a lot of reasons why she would do it, but they didn't prove to me that she did do it. So, like in a case like that, for both sides, I think that the closings are going to matter. I think that both lawyers have a lot of pressure on them to deliver on Monday for both sides. I think that a powerful closing by either side with less pressure on Bloodworth because he has the advantage of being the state and juries convict. So he's got that advantage. But in terms of the defense, I think there exists an opportunity if Nestor can hit it out of the park.
Wait, Nestor is the shorter one or the
Nestor's lead counsel? Like she's the
shorter one,
the heavier set one.
Okay.
What the fuck? What, I can't say heavier set. She's clearly heavier set than Lewis. So they're
Yeah.
both old to me. They're both older gals.
Yeah.
Um,
All right. So then, did you finish your sentence? Your thought? I'm sorry.
yeah.
Nestor can hit it out of the park, right?
Well, but my point is that I think there exists the possibility that she can get the not guilties on the ag and the attempt, but like they're convicting on the 3 other charges because I think they proved them.
I don't even know, like, 'cause I
I
didn't
think
hear
they
so
did.
much of that.
I think they did.
Does
So
one of the charges have anything to do with the HELOC or the home equity loan or whatever
yeah,
it was? Oh, that one I think they proved that he did not know she took out that. I didn't hear all the evidence, so I don't know.
is Lewis the lead?
Lewis did the opening though, didn't she?
Where are you getting that Lewis is the
Who is
lead?
who?
Oh my God. Lewis is the smaller of the 2
Okay.
glasses. Nestor's the heavier set woman who sits in the middle. I think, where are you seeing that, Mal's? Because it's Nestor's firm. I think. Like her and Lewis have a firm together.
Was it called is the firm wait, I sent an email. They sent an email.
I'd have
Let
to
me
look it
see.
up.
I'm looking at the email I got. Came from nestorlewis.com. Babe.
Okay, what's that mean?
That the firm is Lester Lewis. It's both of them. I said Lester Lewis instead of Nestor Lewis, but it's the both of them. So it's not one person's firm over the other. And the paralegal seems to be Lewis's daughter or relative. So
Yeah.
not that that helps in any way, shape, or form. Okay, let's go to.
Where are you guys seeing that?
Well, I think they're assuming it by how she takes the lead a lot, and she sits on the end.
She sits in the middle. Lewis sits on the end.
Right, that's what I'm saying. So that would tend to suggest Lewis is the lead, but she did the opening.
No,
She's
they're
gonna do
saying
both?
Nestor did the opening.
What? Is that true?
I can't remember.
Oh, well, if Nestor did the opening, then definitely Lewis is the lead and Lewis is doing the
I
closing.
cannot remember who did the opening, but I'll take everybody's word for it.
Okay.
Yeah, everybody's saying Lewis is the lead.
Okay.
And then Peppermint Patty jumps in and says that Nestor is the lead. So I don't know.
No, whoever if Nestor did the opening. Who did the opening, people? I'm Googling it.
Wait, but that's not necessarily how it works on papers. But that doesn't mean shit.
What?
Like the order that the names of the firm is. That doesn't mean anything.
No, that could be sound. What sounds better?
Yeah.
Defense attorney Nestor delivered the opening. So that supports what we're all saying, which is Lewis
is
sits
lead
on the end and she's going to do the closing. That makes her the lead.
Yeah, the sitting on the end is.
I mean, that's just.
It's pretty indicative of being lead counsel. Yeah.
Because you're the one that's going to stand up and do most of the talking.
I mean, they split. They
did. They might consider themselves co-lead. Bob and I, no matter who did the opening and the closing, Bob always did the closings. But we were both lead counsel.
Yeah.
And told the court as such.
All right, I take that as that's solid intel. On a news interview, Lewis stated she is lead counsel. All right, that's good.
All right, moving on.
That's me.
Dom's mom, 24 months. OG.
OG.
Hope the jury gets it right. Justice for Eric. And then Kathleen says, now, is this true that Kouri put mushrooms in the girls' sandwich at lunch? Is this just like funny talk?
Wait, did I put love time? Hold on. Did I call it love time? Live time it's supposed to be.
Oh, wow, babe.
Oh, my God.
Wow. That's a whole new goal. Sorry, guys.
No.
I'm going to crank that one up to $1 million. I mean, if we're going to have a indecent proposal.
All right. That's
for Bob,
live.
too. Love time would definitely be with Bob, and I'd be charging the $1 million.
Oh, yeah. So, all right. If you're late, our goal is
Not love with
You-
Bob.
It's not love time. It's live. Whoever wins the wheel will come on for 15 minutes, 20 minutes, whatever, with Allie and I during closings on Monday. You don't have to be on camera. We'd love to have you on camera. If you want to do it and you win and you want to gift it to somebody else who may want to be on with us that maybe is a little tighter on cash, you can
Or just
absolutely do that as well.
Whatever. Just your
Like
neighbor.
Pammy, I don't know if she ever gifted it off to somebody. Pammy won. And I haven't seen Pammy. I think I scared Pammy off.
Oh, well, Bob is scary.
I mean, I'm
Bob is scary.
terrifying.
So was this a joke about the shrooms? I'm assuming it's a joke about the shrooms in the sandwich.
She put shrooms in the girls' sandwiches. Who are the girls?
Right. Did they have girls, daughters?
No. All right. So the goal for the day, it's for a wheel spin for Monday. Whoever donos, and we're going to put you on the wheel, no matter which way you do it, Supers, Venmo, Cash App, whatever, all those different ways. So we're going to do the wheel spin, and whoever wins is going to join us. We're going to send a link, and you're going to join Allie and I on the live to discuss the case, to have fun,
After closing.
talk to one another after closings.
Yeah.
Or maybe, like, if you really want to come on, like, I don't care if they're on during closings, but you won't be
I
able
don't
to
either.
talk as much.
Yeah, that's my point, is that
Right.
there'd be a lot of not talking.
Right. So it would make more sense to come on
After
closings.
discuss it. Yes.
Yes.
But when she says, what's the goal? Does she mean like how much money? Because I was saying $1 million for love time. So what is it now that it's not love time with Bob?
It was always, I just set it at the highest that I can set it, which is
$1 million. Gotcha. Okay.
Oh, like Allie was doing that. Like that was a super grift. Allie was like, anybody who donos 50 gets on the wheel.
No, that was anyone who donated could come on, period. There was no wheel for that.
Oh yeah. Well, I made this one $5 and above.
Right.
Yeah. I kept it reasonable.
Yeah. But we could, if anybody donates $50, they can come on no matter what.
Allie always adds that one in.
Yeah. I should have said 100. Iceman, oh, we did that. Thank you, Iceman. Dom's mom super sticker. Thanks again. And again for your continued support. Ashkin.
Thank you.
Ashen says, let's do squares with hours instead of scores for when the jury comes back.
Kristen, I got your $10 Venmo. Thanks, Allie and Bob. Had a great time watching the trial with you. Well, thank you.
Oh, because remember you said something about doing like a thingamajig? I don't know.
What?
Like a basketball kind of thing.
Oh yeah, the March Madness, like a bracket.
Yeah, is that for how long the jury will be out? Did you put a vote? Is there a poll going right now on?
No, it wasn't. It had nothing to do with
10th?
this trial. It was just like we do a Defense Diaries March Madness bracket, but for no money, and then the winner wins something like some kind of merch.
Right, but isn't there a way where we did some sort of thing where people bought a square and they had between this hour and that hour? Am I misinterpreting what Ashen's suggesting?
Let's do squares with hours instead of scores for when the jury comes from the jury. Oh, so what she's saying? No, she's like talking about like Super Bowl squares.
Right. So that's what I'm saying. Like you buy between 1 to 2 hours, between 2 to 3 hours. You
Like the reason I didn't do I was gonna do Super Bowl squares on with our fam here, and everybody was like, "Don't do it." Like they'll like YouTube will demonetize you. Like you can't do gambling on there for money. So that's why I'm saying if we're going to do a March Madness bracket with everybody who wants to come in, like the prize will not be cash. You won't have to pay money to enter it. We'll just have everybody do it for fun. And then we'll give away like a t-shirt or a whatever, you know what I'm saying? For the winner. Because there's only going to be one winner.
Okay, YouTube, all your listening bots, we are not doing the gambling thing.
No gambling.
Tanya, thank you for your super sticker, and you're on the wheel. Julie says we should rewatch openings during deliberation and see what both sides said. They were kind of short openings, right?
Yeah,
Motion granted.
Motion granted.
Crazy cat lady, I have a black eye right now, so I definitely would not want to be on camera. but I never win anything. I just support y'all. Well, that's very sweet, and I'm sorry. Hopefully your cat didn't pop you in the eye. Those dangerous cats. For the record, no to joining Monday. Love. Oh, Monday's love. I get it now. No to
Oh.
joining Monday's love.
Oh yeah. I cannot edit it. So
You can't edit it?
I cannot edit it.
Oh my God.
So it is what it is.
Oh my God.
Is
People are
what it
going to
is.
come on and they're going to be like, holy shit. Look what the Matas are doing.
Look at these two. What scumbags.
That's some perverted shit.
Oh my God. These
YouTube
preverts.
will demonetize us because we're prostituting.
I need to go to the bathroom.
Oh my God.
Oh God.
Oh my God. All right. Let's start with this a bit. Let's
All
see what
right.
we got. Let's see what we got.
Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos.
Well, maybe Nestor
Let me
just has a
just
better
provide a
relationship
little
with
context for
Corey.
where we are
Sits
at the
next to
moment.
Corey.
I have given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments. Let's just take it one step at a time.
DB, you could do it for free.
Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing
Okay.
general.
Ms. Nestor.
No, Your Honor.
All right. So may we go by page number, working off of the draft that the court just provided to counsel.
I mean, this judge is probably making this super easy for them.
Pages
Did all the
1
heavy lifting.
through
I mean, if that's for real, DB, yes.
1 through 14.
But it's
are
$100
the
if you're doing an ad
opening
read.
instructions that the court gave prior to
Price
opening
goes
statements.
up.
Yes.
Any objection to including those in the closing instructions, Mr. Burmester?
No.
Giveaway.
Ms. Nestor?
Yes.
You want to reread them?
No,
Oh,
I'll
good.
start reading at page 15.
Oh, great. Then
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay, pages 15
I'm going to get some
through
water. Pre-works.
'23 are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial began. Take a moment. Take
No
a minute.
objection from the state.
No
Okay.
objection from the defense.
Okay. Ms. Nestor, pages 24 to 25 is the substance, I think, or is a Muji standard instruction regarding in-custody informants. It would require maybe a little editing to remove some unneeded syntax.
Mhm.
So first, I need to hear from the state about whether they have a general objection. And second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence regarding those periods, because she's not in custody during the time she's on the stand.
Right?
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction,
From the 10th Circuit.
Right.
yes,
See, yeah,
Garcia
right.
instruction, which seems more nuanced for the circumstance that we're talking about. So if we have to have one, then that would be the one we would prefer rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
Oh, she's a
The
snitch.
other thing is, Your Honor, the witness credibility instruction number 20 from page 22
She a rat.
allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as for Crozier. So
Wait, I saw you put this up the other day, Spit. Where's the typo in I love DP, due process? I was trying to figure that out. I was glad you brought that up, because I can actually edit the bonfire store.
that all is great for argument, but I don't know that we need any special instruction, given that neither person was in custody at the time of testifying.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the circumstance with Ms. Lauber, are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction. I think I agree we should probably limit it. When I submitted it, I was thinking all her interviews, she was in custody. But I didn't think about the fact that
Agreed.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal. But I could be wrong about that. So I don't have an objection to adding dates that she was in custody, if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody, but I mean, it doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this, because the immunity agreement also covers federal immunity, state immunity.
Yeah.
I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Oh yeah.
Mr. Vermester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber. It should be
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was in
Yes.
custody, correct?
Yes.
Okay.
Yeah, I kicked the door open. Have at it.
In fact, we saw an interview with him in custody.
Right.
Oh yeah, I want to
Same with
know.
Carmen Lauber, right?
Yeah.
Okay.
And once again, this instruction is designed
Oh,
for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They just happened to be a cellie or something like that. And that's what this was designed for. That is not this case. Both of them were witnesses to the things they observed. There was discussion about immunity. And for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction or something along the lines of Garcia mentioned before.
I need to go to the bathroom.
All right. Let me think about this for a moment. Mr. Burmester, putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand. And Ms. Nestor, I understand defendant's position to be the state should give both instructions properly edited.
Right. It is occurring to me, if the concern is there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flipped on whoever's didn't flip.
Provide helpful information.
Yes, sir.
Yeah.
I don't like that word snitch, but that one may be closer to the facts of this case. I just than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah. Okay. We'll come back to that. We have
Okay.
time. Okay. I've made some notes. We'll return to this issue at some point. Okay. Pages 26, 27, 28. Standard Muji second closing instructions. Any objection, Mr. Burmester?
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
Yep. I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that if that evidence
Hate you.
yeah, that-
Why would I
sorry,
hate you?
that reasonable doubt is
You're
evidence
crazy.
which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be. I understand this particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever. And so we object to the language of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
Okay.
I'm with Nestor on that. If you're late to the party, we are no jury. The jury is not in today. This is the charging conference where they're going through the jury instructions, proposed jury instructions, so they can land on what instructions. The very, very important task, critical task in terms of language. As you can see, this one in particular, in terms of how they're going to define what reasonable doubt is for the jury. As you can imagine, that's a big deal. It's a big deal. So that's what they're going through now. But yeah, jury's not here today. Closings are Monday, and we've got a grift going.
And I'd like to comment on the typo in the grift. It is not for love time.
It's not for love time.
Babe, come on, pull yourself together.
Oh, yeah.
Jesus.
Oh, yeah.
Oh my God.
Oh, yeah.
Oh, boy.
Oh, yeah. All right. Let's go.
I'm not yeah.
I understand.
I'm at
And the
1.25, by the way.
record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P3rd 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah Appellate Court authority, defendants.
Oh, just in case you're wondering, okay, because I could tell some people are wondering, Muji, what they keep saying is Model Utah Jury Instructions, MUJI. Model Utah Jury Instructions. There you go. Muji.
All right.
Everybody loves a Muji.
Objection
Right, I'll be back.
respectfully overruled.
Chase the lamb's tail.
Anything further on that, Mr. Burmester?
No, Your Honor.
Okay.
And then what was the last one you went through, Your Honor?
Well, then we go to page 29,
Right.
which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Nestor?
Yes. Thank you for doing that.
Mr. Burmester, any objection?
No.
Okay. Bear with me, folks. Let me just make sure my notes reflect what we've talked about so far. Okay.
I would expect
That brings us to page 30,
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester.
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction inserts the case-specific language requested by defendant. Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
Do you have any other non-character purposes for that evidence?
yes, Your Honor, like all but one or two of them, I think, can apply.
Well, but as I understood, the only reason, and when I instructed the jury in real time, the reason I gave them was motive. Was you weren't, was it also go to
Can it go
preparation?
to identity, preparation,
I know it
intent?
can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout our briefing since, the entire motions in limine practice. We, argued for the admission based on motive, intent, plan, and preparation, and identity. Those words are always lumped together in our
I
briefing.
know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive. The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
Sorry.
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity. Or determining things such as motive, plan, preparation, or identity.
For the limited purpose of determining things such as the defendant's
Oh,
motive,
boys.
plan. Okay. Yes, sir.
Okay. Ms. Nestor.
Well, I think the court was right initially. I've never been under the impression identity was an issue in this case.
Gosh.
I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct. So I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I just would like the record to reflect we object to it, Your Honor.
Okay, hold on a second. I'll just make a note of this. We'll come back to it.
I would expect the defense, I would expect that Nestor knows how to hold her own in a jury instruction conference. She does a lot of federal work. She's gonna have bases covered, as you could see with the burden of proof, preserving the record. But if they make a change,
Okay.
it's not going to be
32,
retroactive
33, 34,
because they're not going to want everyone being able to
32
appeal.
through 36 are Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural. Many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it.
And then the rest, I don't have any objection to.
Got it. Will do. Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural, which is a little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance. The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the court proposed the version on page 38.
Can I clarify? I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the The only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain.
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example. So go to page, for example, page 41.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3, and then when it gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing that about a motive at all,
Right.
just regarding the act.
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death for the purpose of.
Yeah, the difficulty here is the pecuniary gain is a why, not a how, and why is motive.
Right. That's right.
Well, motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
That is among the things that the jury would have to find unanimously.
Right. The
Yeah.
pecuniary gain is clearly motive. That is a motive that they've alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A. And so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that,
But
Because then
I
we
mean,
don't have to get confused about whether the why is part of 4A versus 4B. We can just not instruct regarding motive.
The state probably wants we don't have to prove motive.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean
Right.
without having to thread the needle of what's an element and what's not.
Let's do that, Your Honor.
yes.
Okay. Any objection, Ms. Nestor, to omitting a motive instruction entirely? A separate motive instruction.
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood. Pages 38 and 37 are omitted. Okay. Page 39 includes definitions. In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It was a sentence that I read regarding counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
It's in the information.
Your Honor, I know, but we didn't pull it as, I guess we pulled it by agreement as an element of offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to
But
conviction.
don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Not
Yeah,
if
I
the
think
defense
that's
is
part of the
stipulating to it.
stipulation is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I just need a waiver of Ms. Richins' right to jury determination on that, and then I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that
Okay.
at sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Okay.
Now
Ms.
ask
Richins,
her.
do you understand the rights you're giving
Yes.
up? Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary. On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Ledward?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay,
This
is
is-
this,
This is going
Mr. Burmester, is this
swimmingly well, the way the parties
definition
are
of
all being
attempt?
reasonable.
Yeah,
the same as yours
Yeah, that was added by the court before I ever
before you
got a
did this?
chance to ask anything with it. It appears to be the same thing, so.
Okay. Just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah.
attempt?
We'll need to take a break, so put a pin in it if you want. And
Just take me
Okay.
1 second.
What was that, Allie? Okay, so unfortunately, Bob's not here.
Okay.
I can't
All
pause.
right,
Let me
so
try to
we can
get
just toss this,
the
right,
feed
Mr.
at the
Burmester?
same
We can throw
spot
this out.
Yes,
Okay.
absolutely.
Bob is.
right. No objection to the rest of the definitions instruction, Your Honor.
Okay.
Or to number 40, which comes after it.
thank you. Mr. Bremer, is there any objection to page 40?
No,
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a
Damn
jury
it.
find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It would be a lesser included offense. So I don't know how to carve out.
All right,
It's my
I'm just removing it, and I've got to try to find it because okay. So I paused us at the waiver. Oh, wait, sorry. Because there was a lot happening, and I think we need to slow down and discuss all of this. So now we'll talk about the domestic violence issue. So part of in order to be sentenced, for your sentence to be enhanced under the law, it has to be on an issue that the jury found the state proved beyond a reasonable doubt. So apparently in the charging instrument, it mentions that they are domestic partners. So because the defense decides, hey, I don't want to say the words domestic violence, I don't want to talk about it. We think that that alone is like prejudicial, some kind of, trigger word. So what they did there is say, look, very easily is going to be established that they were domestic partners because in order for violence to be considered domestic violence, one of the things is that you cohabitate, you live together. Obviously, that is a non-issue here. So the defense is saying we will stipulate to that fact so that the jury no longer has to find beyond a reasonable doubt that the state has proved that these two cohabitated. So when we get to sentencing, the sentencing can be enhanced, which means worsened. It can be, it's a factor that can make her sentence worse. So yes, Matthew's saying, does that mean it could get longer? Yes. The judge had to go through that exercise so that if she's convicted on either of the violent charges, 1 or 2, murder or attempted murder, that they can sentence her harsher because she attempted the murder and or murdered a domestic partner. So that's what we did there. And now I've started it back right at when he took that waiver and said he found it to be knowing and voluntary. And it really is a non-issue, as you can tell. Like, clearly they live together.
On that basis, I'll remove any reference to cohabitant throughout the instructions. Agreed, Mr. Bloodworth?
Yes.
Or Mr. Mercer, sorry. Ms. Nestor, any objection?
No, Your Honor.
Okay.
Okay, is this, Brett, Mr. Burmister, is this?
Right, and they
Can I
had
just
this
compare one
little
second?
discussion.
Mr. Burmister,
They-
instruction, Your Honor.
Aggravated murder, count 1,
Okay.
pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's
All right, let's walk through what she's saying, because I was about to pull up the pattern instructions so we could go over it, but
be fine. There
let's
the
hear this one more
concern that
time.
I have, and the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really married to how we address it. I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone, thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance, it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So
Are
I
you
don't
asking for
know
that?
how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone, and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that I think you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Okay.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right,
Under 76-5205.
right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
Right.
I agree with that.
So I don't think I have to include that language in the elements. The real question is whether you're asking for a lesser included, or I mean, you could certainly argue to the jury some
That's-
factual inference that,
Yeah.
listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
That line of reasoning or doubt.
So
But I don't think the state has to affirmatively prove without a reasonable doubt that this isn't assisted suicide manslaughter.
So I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died.
I agree.
So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and he eats it, that's not aggravated murder.
Well,
Even
here, let me,
Well,
I'm going to create a very morbid and dark hypothetical.
This
Right.
is all
I can
morbid and
see
dark.
it.
Imagine a healthcare provider
Right.
says to a patient,
Here, take
would
this.
you like some morphine to help with your pain? They say yes.
And he gives him
And then
fentanyl.
pushes the plunger way too far intentionally. I think that's
there's an
still
intent to
aggravated.
commit. That's an intent to cause
To
death,
cause the
though.
death. Yep.
Right. But we've got witnesses of the state coming out talking about
Mm.
you can be fooled by these pills. I mean, they put that testimony
Yeah,
out,
but that's a
right?
different element, right? You're down on 4B.
I mean, this is a very interesting, like mental discussion that's going on. All right. So we're talking about whether the definition of murder that they're going under, that you administered, I think that's you not causing the administration, but you administering it, meaning giving it to him surreptitiously would be, in essence, you administering it. But I don't. So let's hear how it plays out, and then I will pull up the statute. I mean the jury instructions. I'm just having a hard time searching and listening. So I'll wait till Bob comes back, so that at least one of us is paying close attention while I'm trying to find the instructions.
I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level. That's homicide. It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
Yeah.
And Your Honor,
Now,
this-
I'm doing all the heavy lifting.
from reading the tea leaves on how the facts came into evidence in this argument,
We're
the
gonna want to
state has the
Less
state is
included.
concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that the defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
Yeah, it
No,
is.
But would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder.
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together. You know, we've split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together, sure, that is fine. But intent is not an element of 4B. Like in
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death, intent to cause a result. That's where the intent lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter. Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, I mean, this is the way the elements instructions under Muji typically work.
It's confusing.
You can send a strongly worded letter to the Muji committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike.
To the
Let's
Muji
just go down the
committee.
page here. Mr. Burmester, did I cut you off there?
No, Your Honor.
Okay. We're going to strike the language without the knowledge or consent of Eric Richins, because the court rules as a matter of law that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay. Then we get to the extra italicized language, of which I've provided two versions, one more elegant than the other, and the more elegant one isn't mine. But rather than have a separate instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
You're right. Because I was going to say, I thought we did this, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
Let's be clear. This was Melanie's idea.
Yay, Melanie.
So we're talking about the top.
So you've got
One with A and B,
you got
right?
2 options here, right? You have the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Oh, you're right. I'm sorry. We'll put reason instead of motive in there. Good catch. So, Ms. Nestor, if we were to see in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The state has proven.
Yeah, we can do that. Do you want to say which circumstance or circumstances the state has proven?
Yes.
Yeah.
Or just put an S in a parentheses, like so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. I'm just going to read it out loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated
glad you're
murder,
back.
you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that
Yeah.
sentence. Got it, thank you. And we'll just keep you, we'll mark your decisions on the verdict form. Okay. Ms. Nestor, anything else there?
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here.
Now I'm not
Okay.
sure
No,
what they
that's fine, Your Honor.
decided to do
Okay.
about the
I will
surreptitious
make
thing.
similar changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
Okay. With respect to the definitions of mental state, murder is one of the, or homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime, right? notwithstanding your best efforts, if you don't kill someone, you did not commit homicide. So the mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But I have no objection to proceeding with the way the court is laid out.
Okay.
Right, 'cause
The mental states definition on page 46.
right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate. I don't know. I always question whether jurors ever understand this, but I think this is the best shot we have at getting it to them.
Yeah, in fairness, I should probably move mental state defined counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions, I think that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay, Ms. Nestor.
So you're going to move what's on page 46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is the same language we had. Yeah, no other objections to that.
Okay. All right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look at the statute. Bear with me for 1 moment. It's insurance fraud, allegedly committed.
All right, so now
All
we're
right, so
getting into
let's focus on count 3 for a
3,
moment.
4,
It's
and 5.
insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76,
Here's your charging.
6, 521,
D.
2D, right?
Yes.
All right, so
So-
let's start with couplement mental state. Because
So before they get too deep in the weeds on this other stuff, I don't think if I'm the defense that I am going to ask for the lesser included of the, giving some, whatever their version of, they mentioned assisted suicide, but I think if it was, that you gave someone a drug that contained fentanyl even at their request, because it probably carries a shit load of time, so they're like, nah, the state didn't, allege it. And as of now, the defense didn't ask for any sort of lesser included. I think we're going to go back after this, and I'm unsure where they ended on or if they're revisiting whether, 'cause she brought up, well, I think that the state has to prove beyond a reasonable doubt that she surreptitiously administered him the drug. And I was sort of like looking for the jury instructions, which I have up now, and I went through all this trying to get it on Westlaw, and it was just openly available on Utah's website. So we should put up a banner. Babe, put up a banner. It says outside of the presence of the jury and what we're doing. And we'll keep going.
the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
But it says it specifically in Part D.
Oh, with the intent to deceive or
But it's
defraud.
a specific intent.
Oh, there we go. Yeah, so this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Okay.
Yes.
Devises a scheme or artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So 2 questions here. I don't see from an insurer anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's why.
So we'll take that out. And then Ms. Nestor, in your submission this morning, you make reference to 2D's
Right.
phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection 521(2)D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute.
521D2. Oh.
Excuse me.
All right, just a minute, Your Honor. 76 6 Here it is. Okay, I'm with you. Please continue.
All right, so 521(2), an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain two categories of things in the alternative: fees for professional services or anything of value, and then
Or
by
anything of
certain
value.
means. Why doesn't it apply equally to two alternative categories of things?
Or
I
anything of
read
value.
that differently.
Okay.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false representations about what I'm selling you. I'm selling you something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by
I think
means
she's
of
right.
lying to you about what it is I'm doing for you. That is what I think this is. And that is not anything to do with Ms. Richins. I think they liked that second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that I've represented them. They go around and they sell junk. They sell a policy that doesn't cover anything. And they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product. And it's fraud. And that's what I think they're talking about in this crime. And I don't think it applies here. And I want the word fees in there because I think they picked the crime. They got to prove it as it's written. And they just.
I mean, she may very well be right, and she should go back and do a little bit of, statutory intent here. What was discussed when they passed this statute? Because if this statute, what the defense is saying here is this is a statute designed to target insurance brokers or people selling insurance so that they do not defraud the consumer. It's like a consumer protection type crime, not when you, the consumer, defrauds the insurance company. And she's arguing that the state picked the wrong crime to charge her with. And that's not what this crime is designed to prevent. Let's see what the judge says.
Just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or.
Mm-hmm.
And I can't consider the word insurance in the title of the section. That's
'Cause it also
non-substantive.
says file an insurance
In fairness, I see that the
claim.
word insurance appears in section 2, so I understand. I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. I mean, the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications and the communications fraud isn't doing much besides requiring that somebody communicates something by speech, writing, whatever. I too wrinkle
No.
my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision limiting the scope of this statute?
I tried. I looked. I couldn't find this particular
Issue.
because I just kept reading it over and over, and I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And I object to taking any words out of it exactly as it's written, because I don't think they proved this. And I actually think they charged the wrong crime. I don't think that applies to the next two, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
Well, depends how you read it. I mean, if you take out the words or anything of value, or
No,
it doesn't
I
make
wouldn't
sense.
take those out.
No.
Yeah.
I'm saying for
Yeah.
purposes of trying to understand it in context, right? So like the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services, comma, or anything of value. And their reading of that is that or anything of value goes back to a
Yeah.
scheme or artifice to obtain.
Professional
But I don't think that's
services.
right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
Okay, but even in your world, in your view,
yes,
I hear you saying it would be 1, Kouri Richins; 2, with intent to deceive or defraud; 3, intentionally, knowingly, or recklessly devise the scheme or artifice to obtain
fees for professional services.
3A, fees for professional services, comma, or 3B,
But that's,
anything of
That's not-
value.
that's not how it's written, though, Your Honor.
It's exactly how it's written. I
No,
just
it's-
put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected.
Right.
I don't think it's written that way.
Oh,
Right.
okay.
What about where the comma is?
Well, then we should take the 1, 2, and 3 out as well.
Take the which
Never
one?
mind. I understand your point.
Yes.
Okay. Mr. Burmester, go ahead, sir.
I think she's right.
If we're going to add the theory that we're not proceeding under, then it should be A and B
No,
to make it clear.
but it's
because
not.
It is an alternative.
I think
It's a list of two.
I think the judge is wrong. I've got to go back and look at this. I was trying to see what the definition of runner is, because what the statute says, it's under the insurance code specifically, and then under the insurance fraud, and the statute that they're talking about says in the beginning, as used in this section, runner means the same term as defined in a different section. So I went and looked at that section to see what is a runner. Does it mean like someone who runs insurance? And it said like a capper or a something. So I don't know if those are words people in the insurance world know. But when you look at the statute, I'm going to share this tab instead. Okay. So we're talking about B here. So an actor commits a fraudulent insurance act if the actor, with the intent to deceive or defraud, B, presents, comma, or causes to be presented, comma, which that you don't need the commas with that or, except to say that middle part goes with the same thing that presents. So it's presents or causes to be presented, any oral or written statement or representation. And then you've got D is what they said they're going under. D. Wait. D. No, so 2, we go right to D. Intentionally, knowingly, or recklessly devises a scheme or artifice artifice, whatever, to obtain fees or professional services or anything of value, right here, or anything of value by means of a false or fraudulent pretenses, representations, promises, or omissions. Devises a scheme to obtain fees for professional services. Well, no, because if she was right, I think it would say fees, comma, or anything of value, comma, for professional services. So what do you think, babe?
I'm not paying attention to what you're doing. I'm doing
All right,
something.
well, what do you guys think? I think now that I'm looking at this, that if it was going the way she said, it would say intentionally, knowingly, or recklessly devises a scheme to obtain fees, and then this or anything of value would go, comma, here, or anything of value, comma, for professional services. But all of the other things, knowing supplies fraudulent material information in any document required by the Department of Insurance. What she should have done is spent the time going over legislative intent. What did they discuss on the floor when they passed this statute, which appears to be effective May of 2023? So there's ways that you literally go, lawyers do this often when they're trying to decide the legislative intent, because so the statute was, you had a 94 version, a 2001. So I don't know, you might have to go back even further to figure that out. No longer requires that a person present a complete fraudulent or false insurance claim. So that it is also dealing with sometimes a person making a false claim, but she's saying they didn't do it under that. All right, let's see what the judge said. Hopefully I'm not confusing you guys even more.
I don't know how to read it any other way.
If that's wrong, it comes back though, because that's not, these go straight to elements.
Okay. So, Mr. Burr, is there any objection to including the language in the alternative form as it exists in the statute?
As long as it's alternatively A or B.
Okay.
I object to the A or B, Your Honor.
Because
I think it should be all one sentence, like exactly like it's written.
I understand your position. Okay. Let me give that some thought.
Because she's saying if you take it and you separate it out, that now it doesn't relate back to the first part of the sentence, and it reads the way the state and the judge are trying to have it read. But she's saying that's not how it reads. That's not the intent of the statute. The intent of the statute is to tie it to fees or something else of value. And like I said, I think that they would have put that little bit before, after fees and before professional services. But she might be right. She might be right. We'll see if the judge changes his mind when he goes and looks. She should have come with some legislative intent material. She should have come with it. Absolutely, positively. It's a huge point, on a lower crime that appears to be a misdemeanor, I guess, if I'm looking at this correctly. I saw someplace where it said it's a misdemeanor. I don't know, but let's just keep going. The judge is reserving ruling on that issue. He's going to take it under advisement.
Mr. Ramos, go ahead.
Just as you were giving it some thought, and I'm looking at 76.6.521, just from the code.
Who's speaking?
An actor commits a fraudulent insurance act. I had missed it. Your Honor probably didn't miss it. I missed it.
Ramos.
Going back to the Insurance Act. That isn't in the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester.
Did we talk about element 4 of count 3? Is it? I'm not
Oh,
sure
he's
where that
on
came
Zoom?
Oh, thank you. Yeah, you're right. I went too fast.
Thanks,
I
guys.
don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
Oh,
on
on
page
count 3.
47.
I'm sorry, I gotta go back. Just 1 minute. I thought we were on 4. Okay, element. Oh, took a substantial step. That came from case law. That's case law.
Have the citation.
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment.
Oh, the
It's
things that
document
make Bobby happy.
1584 On the docket.
I love you, babe.
Love you, honey.
So they panned over to his chair like he would be over here, but he's on. That's what Jacqueline said.
Let me see. I might have written it in my notes.
Seemed that way,
Just a
Jacqueline.
moment, Your Honor.
Right, yeah. I don't know why Lewis doesn't speak up. She's on, as Island Life points out, she's out there too on the WebEx, on the X's of the webs.
Oh no, I don't think that came from me. I don't think that came from me.
It did not come from the state.
I think it did. I can go back to what you emailed or from the parties and was represented as, but it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted.
Oh, I know where this came from. Mr. Bloodworth and I had a discussion about the fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think, and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
I think an act is kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521(2)D would be the devising.
What about the
scheme,
doing?
which I think is Ms. Nestor's point.
Right.
Right.
Well, if you devise it,
I could think of one right
never
now.
say anything,
Right.
do anything, have you violated the statute?
Right.
So what is the actus reus?
Okay, so an actus reus is exactly like it sounds. It's the act. It's what you have to do. Where we talk about the mens rea is the mental state. So you've got the actus reus. That's what is the act, and the way it's written right now. They're saying all agreeing that you can just devise a plan in your head and be guilty the way it's written.
What's the conduct?
by means of, and then those.
Well, but that's just a modifier on the scheme
Right.
Well, thanks,
that you
Iceman.
devised. I think the operative verb there is devising.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
I think the judge recognizes this is an
Why
issue.
don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't beyond a reasonable doubt.
That would be fine with me.
Defense is like, yes, sir.
I mean, forgive me, count 3 is I get confused between count
It's
3
the
and 4.
scheme one with the $100,000 two-stage policy.
Yeah.
The
By the application.
yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but
That's the actus
it
reus.
could also be
Just signing
filing
it.
the claim as well. But yeah,
Okay, sure. Yeah. You could, we could instruct the jury that the state's theory is that
Where'd Bob go?
Kouri Richins committed this crime by A, B, and C. I give it,
Or-
yeah, right, yeah.
Now we're doing A, B, and C.
We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury what the state thinks and either the state proves it or they didn't. Okay, give that some thought.
Oh, and I take it
Okay.
back. It's that
In terms of our initial
It's a
review.
felony
Let's keep
when
going.
it exceeds $5,000.
Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
It's definitely a felony. I just saw where I saw the word misdemeanor. I just kind of was skimming and saw the word misdemeanor.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay.
I would again definitely defer to the defense and
Mr. Burmester, let me know if
knowing
you reviewed it.
better
On
about
board?
jury
Yes, sir.
instructions.
No objection, sorry.
That's okay. So then let's look at elements of forgery, count 5. 76.
not what the cop said.
Dash
That's for
501.
sure.
2B1. An actor commits forgery
Don't be
if,
ridiculous.
with purpose to
Okay.
defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing, so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent.
Wait, what?
This is the signing of the true stage life insurance application, signing of Eric Richins' name allegedly to the true stage life insurance application.
Well-
Correct, Mr. Burmester?
Yes,
Okay.
That would be just signing even if he told you to.
got it.
So we've got to keep with purpose to defraud anyone in there,
Oh,
right?
sorry. There we
Yes.
go.
Paragraph 2.
Sorry, there
Yes.
it is.
Okay. But then I think if I
Is what we said on the live when the cop was like, no, it's just signing his name. That's enough. No, no, no. With the purpose to defraud. And I hope that unlike what we saw in our Colin Gray trial, this defense brings up the jury instructions and points out to the jury where they think the state has failed, because they need to focus on that here, on that piece that says with the intent to defraud.
understand what you submitted correctly, you're asking for without the authority to do so.
Right. That's right. And that's I decided the case law on that. State versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor, that's an element that
Very good. So
supported by those cases.
2 and 3 stay in, correct?
All right. Well, the state concedes that the defense seeking to add without authorization. So they can't prove that one. They absolutely, positively cannot prove. I mean, maybe could they? So that would mean that they'd have to have proved that it's not possible that her husband authorized her to sign. And I guess that would just be circumstantial evidence of what was going on and whether they believe that he would have authorized her to sign if they proved it.
Yes, sir.
Yes,
And then do we need to, can we skinny down 4 in any way to match the state's theory?
He's asking the state, let's be more specific in 4 as well.
I don't know
It's
if we
just the
have
way it goes.
authentication.
I mean, execute and authenticate don't really match the facts of the case.
Is execute just sign?
Yep, because I thought execute meant make it effective.
No.
I don't know. And authenticate usually means notarize or something like that. I
Execute,
still don't know what utter means.
Well, we can go back to page,
sign.
any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing, or just make a writing.
Make or utter.
Yes.
Make
that's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter, or make, execute, or utter?
Either of those two alternatives are fine for the state.
All right. Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing, so that the writing or the making,
How do you utter a writing?
execution, or utterance,
Utterance.
purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean,
Right.
we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Okay. Got it.
They're doing a good
Thank
job
you.
here.
Okay, pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that it is 50, but
Let's see, 50.
it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its
number? Oh,
closing can start with count one and then pivot to saying that you can consider the strength of the evidence regarding count one as part of your consideration of count two.
Okay, I just want to make sure we're
What we
not.
can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but as I read through it, I was kind of.
Okay.
is he talking about special verdict forms?
Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just two.
Okay.
I'll take a look. You will see the verdict form separated into, I'm just going to say several sections.
To several sections.
Yeah.
Okay.
One section for each count charge.
I wish I knew which that they would say.
Any objection, Mr. Purser?
I couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says two. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor.
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmeister?
I don't know.
Ms. Nestor.
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Okay, so this is the
Well,
deadlock jury.
I just don't see the harm in doing. I mean, I think I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree. And that's why you should look at paragraph 3 on page 51.
Oh, okay. Did you stick it in there? I didn't see it.
No, it's just part of the standard overarching unanimity instruction.
All right, so that would
Oh.
be
That's fine.
I recently had a hung jury. I need a place to start to apply gentle pressure to keep working. And this is something I'd like to have in reserve. Okay, so I'm not going to give this as part of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you. Got it.
It's kind of an important section.
all right. So what the judge is saying here is they have their unanimity instruction that basically says in the end, your vote must be your own. A unanimous verdict must reflect the individual, careful, and conscientious judgment of each juror as to whether the defendant is guilty or not. And it says a little bit more like don't get pressure from the other jurors and don't give in to pressure. But he was talking about the deadlocked instruction, that he wants to have it ready in case we need it. So that will only come in if and when the jury reports that back that they are deadlocked. And that's what they're talking about now.
Okay. All right. May we please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one at a time as if we were jurors answering it to make sure that it flows correctly.
Okay, give me just 1 second, Hannah. I'm sorry.
I think
Unless it's at the beginning. I don't think I got a copy of the verdict.
it was in the email
There
that
she
I
is.
sent after I sent a copy of the jury instructions.
I did not receive that email.
Hold on, Wendy. I'll send it to you right now.
That is
Just
entirely possible.
Thank you.
No, you did. Or at least I sent it.
I didn't get it, but
let me
I
forward
think
it.
maybe just resend it.
Yeah, I'll send it right now.
Thank you.
I just sent it.
I should say skip to count 2.
Or and take out 1B. And so this has to change to right there. 2. So I'm gonna Take out 2B. Okay. Okay.
Oh, if we include it. Yeah. Okay. So let's see. Let's start with you, Ms. Nestor. So we'll take out the plural of inquiries and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right,
Same for count 2. Similar changes.
right.
Any other changes?
Yes, so I have some worries
Sorry, guys.
about it not being, I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would solve it.
Okay.
That would be that takes care of my concern.
So that concern deals with you can't give a jury 2 different options to find a path to guilty, and 7 of them agree on one option, and well, there are only 8 here, and one of them agrees on another option, and then you say, "Oh, they're unanimous." No, 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 no. So what the judge is doing here is saying, check all that you unanimously agree to. So although we can't see exactly what they're talking about, that's why that's an issue um, under the law.
Because my worry would be they would mark them both and we would never know that they were unanimous on each,
Okay.
or if they split it half and half. Does that make sense?
Yep.
Okay.
Obviously, because he's fixing it.
Any
No,
objection, Mr. Burmester?
No,
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun on the ball. Just for flow sake, right under guilty of aggravated murder, the in parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
Sure.
After that.
That's fine.
Actually, that does make more sense.
no objection from the state.
Got it.
So they're making sure we don't
Same
have
one
any,
Remains consistent with the.
And
Any
same under count
issues?
2 as well.
Got it.
like we had in
Okay.
Karen Reed.
Then, before we take a break, Ms. Nestor, may I go through just what you submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment. Okay, I'm ready.
All right, we handled the quote without the knowledge or consent of Eric Richins
Right.
language on the record. Changing her to there, I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's
Oh, okay.
a problem anymore.
all right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Number 5. Why don't you have sufficient a foundation pursuant to the witness credibility instruction on page 22
We're talking
to
about
make
the-
exactly this argument? I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
I think they're back to like the snitch instruction or the other instruction. I think that's what they're talking about now.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the
Ah.
stand, that gives them an edge. And I think a jury can consider that. And I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction, because
So they're talking about the lead investigator, and that is always the case in a federal criminal case. They always have, like, the case agent is just sitting in the courtroom, chiming in on everything, hearing everything, and then sometimes might even have to testify. So it comes up more, I'm sure, in federal cases, unless they do this all the time in Utah. Out where we practice, there's no cop that gets to sit in the whole time, listen to everything, and then and then testify in state court. So that's what they're talking about now. And the judge is like, well, can't you just argue it to the jury? Can't you say, well, you've got to take detective so and so's, I forget his name, testimony with a grain of salt, because he sat here, he heard all the weaknesses, he heard any points that we scored, he heard our arguments, and he knew exactly what to say to you when he got up here. And she's saying, well, yeah, I can do that, but I also want them to hear from you that it's actually something they can consider when they're judging his credibility. Let's see what the judge says.
Driscoll was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
And,
Okay.
and can I just, before you
Sure.
rule, Your Honor, I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I
He's not
will,
doing
with
either.
the benefit of counsel's argument, take a fresh look at Portuondo versus Agard, and after the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further,
No, Your Honor.
Mr. Burmester?
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's
I
handled.
don't know which one they're talking about there.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for a re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. We'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments.
That's the snitchy one.
Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
Spoliation is a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
And how did you? What did we? Does anyone know?
Break, or do you want to just go
Let's
knock
take
it
a
out?
break while you
Well,
get
we'll
that
talk
lined
about it
up.
on the
But
break.
I, like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So,
Yeah, she knows, Your
Mr.
Honor.
Burmester, anything before break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
Just saying the words is not enough. Does anyone know what this defense is arguing the state spoiled, meaning destroyed? Because I'm not sure that there's some evidence that they would have had, but the state. Oh, I got it. The bottle, the prescription bottle. Did she prove it? Did they lay the elements? It has to be intentional. They have to know, and I don't see. I'm in the jury instructions, and I don't see one called spolliation. I don't know. Maybe it would be called something else. We are live, by the way. Did I miss it? Does anyone who was paying rapt attention know where the judge came down on the whole, and it might be this Garcia case, and maybe it's still open, the whole intent and the surreptitiously gave him the pills, like, what was the answer on that? Does anybody know? Because that was when I was still looking for the instructions. I don't it's under advisement, Living Story World says. Okay, so I clicked on the wrong one. Oh, I keep clicking on the wrong one. All right, so it is one of the things he is considering now. Okay, it's very interesting. Let's actually see if I can pull up I got the aggravated homicide instructions. So let's see. Aggravated murder elements. I don't know. Does anyone remember if they went under 2021 or 2022? But let's share this tab. That the defendant is charged with aggravated murder, you can convict her of this. You can't convict her of this offense unless you find beyond a reasonable doubt, based on the evidence, each of the following: that the defendant intentionally or knowingly caused the death under one or more. We'd need the circumstances. So that's probably where that comes into play. Well, it's definitely not 2, because 2 is, I don't think that they're going under reckless indifference. No, definitely not. I don't think. All right, well, we can't tell from this without unlawfully causing death. All right, so that's one of the things that would be in this: insert all applicable aggravating circumstances, which I don't see like as a list over here. Okay. Was it 2 for pecuniary gain? Is that for pecuniary gain? That was the aggravated circumstance. But where's the language where she's saying, because it was something about specifically explanatory note, that she administered a lethal dose, and I don't know where that language came from. Well, I guess we'll hear about it when they come back. Let's see what y'all are saying. Hit some of these, I guess. Oh. Wookie mistake. New member. Welcome. Family hug. Let's see. Majin Kazoo says, my wife walked past while I was watching the replay last night on our TV, stopped to look at Bob and asked, is the judge watching himself in court? Oh, that's funny. Was that the actual Bob or like the picture of Bob as the judge is what I'm assuming. Stop to look at Bob. Oh, boy. That's funny. Birdman says it's 0 miles to Chicago. I got a bottle of bourbon, a half a tin of Zin. They're 40 miles per hour winds, and I lost my sunglasses. Hit it. Oh, so that's like a Blues Brother reference, or is that um yeah, no, that's gotta be Blues Brothers, right, Birdman? Gotta wait till Bob comes back. He'll appreciate these comments. Who's the guilty? Says, think about this. If he had no other drugs in the toxicology, right? He had to ingest pure fentanyl. I find that very sus. I can tell you this whole thing about the toxicology report has me so mind boggled. Okay. I understand it doesn't matter how he took it and didn't have to be in the mule, but that's what the state said. He only drank so little of the mule that there's no alcohol, barely any alcohol in his system, and there's no alcohol or liquids in his stomach. How did all of that fentanyl get in the man's stomach? She did not crush up so many pills that he got 5 times the deadly dose or the lethal dose in such a small amount of alcohol that there's no actual alcohol in the system. I cannot for the life of me fathom what the hell really happened here. Why is her medication also in his system? When did it get there? When did he take that? So it's like, seems like, earlier in the day he took that and it's almost gone from his system. I just don't get it. The toxicology in this case is just mind blowing. And I didn't think that the actual toxicology report, I thought that showed like trace amounts of fentanyl and it was the stomach contents, but yeah, who's the guilty? It's all very sus, like he didn't just chew it up and swallow it. She couldn't have spiced his drink with that much that him consuming the smallest amount of his drink put into his belly 5 times the legal dose. Unless he was licking unless she had the little pieces of salt, like Bob said, sprinkle, sprinkle, but we know that that's not actually the case. Um, and then we've got, oh, I almost forgot. Susan M., new member. Welcome. Thank you. Family hug. I wish Bob was here. And we have a lot of you still, making fun on the love goal. So Monty Joyner says, I want love time with Bob, like Bruce and Eric. And Yellow Jacket says, I hope I come on Monday's love. No love for you. No, love for all of you. Love for all of you. Kelsey, the forensic nurse. Wow. All right. Welcome, Kelsey. I'm just, wow. Kelsey over there. Snazzy little picture. I had to blow it up. Forensic nurse, watch out. Sorry. I don't mean to be what's the word? Objectifying you. So we'll move on to objectifying Feet on Faith. Oh no, those are adorable children. Okay, sorry. And Feet on Faith says, just so blessed to have a safe place, drama-free to watch trials. I appreciate all your hard work. Well, thank you very much. And your daughters look delightful. So I'm sure you're blessed in life as well. Shaboogies says it feels like I'm watching Tyler Robinson's life be thrown under the jail in slow-mo. Well, I mean, words. Thanks. Lozo for life. Loss of for life. No, Lozo for life. Firecracker says, I know someone who gave her son an unknowingly pressed benzo. So it was unknowing to the adult or to the son. He went home on his 21st birthday, had a beer, and never woke up. Oh my gosh. She's serving 17 years right now. Why in the hell would she give her son benzos? Ugh. That's the saddest thing I've ever heard. It's horrible. Thanks for sharing, Firecracker. All right. Made of questions. Monday's love sounds fun to her. So count her in. No. Monday's live for anyone who doesn't know. It's coming on live on Monday. Lawsy C says, love you guys in the DD chat. A great bunch of people. I've already enjoyed watching the trial with you all. I am learning lots. Oh, that's sweet. Appreciate it. Oh, Birdman. You always can tell when Birdman's on one. Wife is out of town. The odds of shenanigans are quite embiggened. That's I'm not even sure who the whole embiggened thing is. Like, that's a person in the trial? It's like, I've been seeing comments, I forget, I think Bob told me or somebody told me. So Gina says she's behind, but a runner in insurance, as a professional insurance agent, is collection of premium. So it does seem like that statute, that portion of the statute anyway, it is designed. Oh, Embiggen is Emily D. Baker. I don't get why that's Embiggen though. I guess because you say MDB. No, I don't get it. Is that like uh, is that a term of art she uses? But thank you for letting me know because now I get it. But yeah, back to like what Gina said, it does seem like. Let's make sure this thing is live. Yeah, mine's playing. Mine's live. Yes. And that's one of the things the judge is discussing right now. Is that statute, does do the or other benefits still refer to a benefit for providing some sort of professional product, professional services, from the insurance adjuster or broker or whatever the case may be. So, thanks, Birdman. Stay out of trouble. Birdman likes to leave messages when he's been drinking. When we used to do the messages that we played on air, we could always do that as another grift, because those are fun. Or as a members live as well. We should do that. Kathleen, thank you for your generosity. The girls are Lewis and Nestor. It was a joke to explain why they stared at each other after lunch when asked who they want to call to the stand. So I guess somebody was, oh, the sandwich. Oh, okay. I'm with you now. Okay, so earlier, I think it was Kathleen who made the same comment that Kouri gave the girls, and that would be Lewis and Nestor, mushrooms on their sandwich at lunch, which is why they came back and just stared at each other right after they told the judge they're ready. And we got, oh yeah, we got people just lined up in the hall out here. We totally ready, totally ready, totally ready. Thank you for clarifying that. I'm glad I was able to put it back to what it belonged to, which is hard in my age with my brain. But thank you for your generosity. And Piccolo, hello, member for 20 months. She's OG. Been here since hearing you both on with Brent and Alice. Yes, we know you have. We love you. Thank you for your continued support. OG. Dog grooming Danny, sorry. Says Bob bringing back the only fan. I mean, we do need the only fan. It's like looking at this just stagnant, seal of Utah doesn't cut it. I need the movement. I'm still sort of missing that for sure. All right. Mama X says, if I by some chance I win the spin, I'll have to pass on love time because I'll be at the office on Monday. No love time while in the office. All right. I mean, Bobby's got to stand behind his typo that he cannot fix now. Cannot fix. The judge is really, this is like quite a break. He's back there researching, and I wonder if it's like the insurance possibility or the serendipitous, pill possibility. But these are the situations where I know the judge he's putting in the mental thought, he's putting in the time, and he wants to make the right decision. That we know of this judge, for sure. And the only times I've heard him make mistakes, at least I think there might have been a couple others where I was like, nah, you're not making the right decision. But he's gone back and righted the ship. I do want to say, like, I don't see how in the hell he in his own mind didn't, when he's making the arguments yesterday, that you're telling me that you can just get in just about whatever somebody said, some bullshit the crank from New Jersey makes up, just to say the effect on the listener. And I'm like, Your Honor, isn't that what you did with the fucking sandwich? Isn't that what you did with the jail calls? For zero relevance and no probative value, because her response to some bullshit theory about, oh, sure, I left the sandwich on the chair and wrote a love note. That's the same fucking thing. It's the same thing. And he took such offense with it when it came from the defense that I just didn't understand how he wasn't thinking back to what he did. He already let all those things that he was like, we're going to let in, blah, 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 blah. He already let all those things in one way or another, either through the jail calls, through the, what's his name's girlfriend. They literally let her say what she heard her husband say, but saying, I'm not going to let his testimony come in. It's already out there. It's already out there. But thank you, Mama X. We talked about crazy cat ladies, black eye. Oh, the jury deliberations. I was thinking, do we have time to do that now? But we don't. All right. I think I got all your. Oh, no. New people have come in here. Let's see. Iceman agrees with whatever I say. Thank you. Blessed Texas. I don't know if maybe I didn't. Thank you for always explaining everything so well. Well, you're welcome. And thanks for telling me I'm explaining well, because maybe sometimes I don't. My mind jumps around sometimes. Often, I might say. Michael is headed to Chicago tomorrow for St. Patty's festivities. Nice. Be safe. Obviously, you're Ubering in Chicago anyway, or walking. And
Oh,
I wanted to be under you.
are they done? Oh, that's what she
He's
said.
out there contemplating the outstanding issues, which includes that statute. I don't know if you were here for that, whether the statute really is geared at stopping insurance fraud against the consumer, at least a portion that they went under. And so whether they should separate out the um the possible alternatives, this whole serendipitous giving of a pill, how they address that, a couple of other minor things as I see it. But he's out there for a while, and I feel like those are the two that he's spending most of his time doing. Oh, I wanted to let you read Birdman's comment.
It's 0 miles to Chicago. I got a bottle of bourbon, a half a tan of Zin. There's 40 miles per hour. Yeah, the wind is right. And I lost my sunglasses. Hit it. Tip of the cap to Blues Brothers.
Okay, that's what I said. That's what I said.
Indeed.
I was like, Bobby will appreciate that.
Oh, yeah. Oh, yeah.
Bring it back. There was something else I said I wanted to bring back for you, but I forget what it was. So,
all right. So are they coming back?
Yeah.
Okay.
Johnny, yeah, keep working on your wheel.
I got the wheel fired up. The
Well,
wheel.
you got a bunch of new stuff while you've been gone. Johnny, New York says, is it not fishy in narcotics bottle prescribed? Oh, that was the other issue. I'll tell you. Prescribed 6 years ago is found in his nightstand the night he died, but isn't tested and then is destroyed. I find it fishy as all fucking hell.
Yeah,
because
and they can't find it.
That somebody saves a prescription bottle like that. In my opinion, one of the reasons one might save a prescription bottle like that is because they fill it with pills every now and then.
Mm-hmm.
You know, so it's at least they can say, no, this is a prescription for that.
Yeah.
I mean, why else do you have an empty 2016? Wait, we're not done with this.
Oh, yeah. Oh, yeah.
Now you got me distracted on that EDB thing, but so they asked for like a spoliation instruction, and the judge is like, well, you don't get to just say the words, you have to prove the elements. So maybe I should get us some elements on spoliation, but I mean, it's going to require that it was like intentional with malice or maliciousness, or they knew that it could definitely hold. We saw it in Karen Reed, but you had a different judge there. But still, I don't fault the defense for arguing it, and maybe they're going to make a strong argument, but it's going to be an argument when the judge comes back that they're going to make. So I had asked, what is embiggen? And they said EDB, which I was assuming is Emily D. Baker. I still don't understand what that means. Equal, enlarge what is on screen.
So Bloodworth had said, can you embiggen what it is? And I'm like, did he use the word embiggen? So I Googled it. So the word
has nothing to do with Emily D. Baker.
Well, she uses it, but it comes like the Simpsons in 1996 are the ones who actually made it popular. So popular that it actually got into the dictionary.
Nomenclature. Oh, the dictionary.
Yeah, but it was a Simpsons episode in 1996.
Oh, so embiggen means enlarge something on the screen.
Yeah, like
okay,
exactly. It came from the episode Lisa the Iconoclast.
Wow.
Yep. So there you go. And Emily adopted it. Now, if we were to use the word that we made up, which is disagulate, that is a word that is truly a word
truly made up.
Yeah.
You can use it for anything.
Yeah. Wow.
Look at this disagulation.
Look at this disagulation.
It could be a kerfuffle is definitely a disagulation.
Kerfuffle is 100%.
Most assuredly a disagulation. If you guys are about to get in some shit, y'all be disagulating. There's gonna be some disagulation this weekend.
Oh yeah. We're gonna go.
Birdman he's got some disagulation coming.
Oh yeah.
He's gonna be disagulated.
The word of the trial is the side note. No question about it. No question about it. Side note. Your Honor, can we have a side note, please? Oh, yeah. A what? A side note, please.
Which witness asked that? Was it the forensic accountant or something?
She was female.
I think
It was
maybe
one of the
foren-
first couple witnesses.
Not the forensic accountant.
No, I want to say she was a cop.
Who
Do you guys
remembers?
remember? It was one of the first 2-3 witnesses. I mean, that tracks. It tracks. I think anybody who watches the
Simpsons a
Simpsons,
lot.
it's kind of like,
Gibson, Woody. Somebody said Gibson. Somebody said Woody. I don't think it was Woody. 'Cause
I think it was Gibson because it was early. It
Who was
early.
Gibson?
Chelsea Gibson.
Was that the friend or who's? I forget who she is.
No. What was her actual?
Oh, she's the lead. She's the lead CSI person, or like she collected the evidence, or
Yeah. Can
Right?
we have a side note, please?
I forget what was she trying to.
I'm Jess is wondering if you've got that paused.
No.
No.
Oh God.
Oh boy. She
No,
had
I didn't have it paused.
Oh, you had it paused. It was paused.
No, I came in, made sure it was playing, and then I think when
What
I
a
pulled it to the end,
Uh-huh. And then it paused it. That's what happens to me.
paused it. All right, we're live. But thank you. I
Oh.
don't know how that happened. I specifically was-
That's what happens to me all the time. Like sometimes it'll like when I slide it all the way to the end, it pauses.
Thanks, I'm just saying.
And biggin is from a South Park. It means to make bigger. I think it can't be if it was first in a Simpsons episode in 1996.
Yeah, I mean, South Park likes to adopt Simpson.
Oh yeah.
Who doesn't like Simpson stuff?
Oh, why am I being disadulated? Good job on the spelling, Birdman. See, you've already used it. Disadulation. Oh man.
Look at this disadulation. Fucking sitting here.
No, it's a disadulation. All right. So, like, how many of the jury instructions are left?
It's just the resolution of like these issues that are outstanding. They got through everything.
Oh, okay.
Stuff he took under advisement, stuff he wanted to research more thoroughly. Why don't you? Did you start a poll?
No.
We started with like 1,200 people. We've got like 600.
Oh man. Yeah,
That's
you're not
what
gonna,
happens when you leave me alone. I'm not nearly as entertaining as
you're
you.
not going to keep it. Had nothing to do with you, honey. It's that charging conferences are boring.
Yeah.
You know, they're just. It's not. It's some highbrow nerd law shit.
You gave Firecracker a hug.
Aw, family hug, Firecracker.
And then, yes, Tina, our best thoughts, is the one who said "Embiggen" is also from a South Park.
Indeed.
Means to make bigger.
Let's see. All right. So, what do you want the poll? Tell me
About second degree. I don't know, unless you guys have a thought, but I feel like we
What-
haven't
what
done
do you want
second
it to be?
degree. All right. How about this is what I also want to know. I think we answered as jurors, right? We know what the people, we have a much smaller crowd, but the percentage should still probably be the same. But so here's the two possibilities. We know what the people, if they were jurors, their verdicts would be. We have a percentage on that with guilty and
Mhm.
not guilty. I'm interested to know if that's different than your like personal opinion. If you were just as a trial watcher, as a spectator, did she do it? How about we have a did she do it?
Wait, is that for the jurors or is that
No, that's for
folks?
the people. It's not whether you think the state has proven its case. It's whether in your heart of hearts, do you think did she do it?
Okay.
But let's ask the people, or we can just go with the second degree as them as jurors. You know, like take off your jury cap, take off your, your the defense is, you
Yeah,
know,
we're
innocent
going
until
we're
proven-
going with your gut here. This is
yeah,
the
like
gut, this is the gut.
what you actually think, not whether the state proved it.
Yeah. Like Allie would be a hard yes on this.
I think so.
Uh, no way. No
Oh,
way.
he's
All
back.
right.
He's
All
back.
right, I started it. The poll is started. In your heart of hearts, is she doing?
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right.
He's been completely
let's-
worthless the entire jury instruction.
Ms. Nestor, go back to your submission this morning. We'll use that as a list here. First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity
Not gonna do
to
it.
listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility.
Mm-hmm.
The court has re-reviewed Portuando versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law.
Rejected.
So the defendant's request for a jury instruction to that effect is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then let's look at the first 2 pages of the additional instructions that I sent out. Page 1 is a proposed instruction called Informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled Immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these 2 pages in this form, which are not specific to any individual, and use the pronoun they,
No objection.
in place of Muji second CR 415, which is the custody informant. Mr. Burmester.
The state objects to number 1, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first sentence of this instruction.
Well, who doesn't? I missed him. What he said.
The
Lauber.
reason she is providing evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number 2.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified. Both she and Crozier testified to the events they saw.
That's why.
Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant. An informant.
Draw the distinction for me. What would you see the informant as being?
All right. So he is actually making not a bad point. He's saying an informant is like you're like your typical snitch is someone who like hears information and then brings it to bear. It's not like a witness or no, it maybe would be a witness, but it's not like a co-conspirator. And she said Nestor said, all right, then let's use the federal unindicted co-conspirator instruction, which I thought makes perfect sense in this scenario. So I
Mhm.
think he's going to give some version of one of the two. So
And I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So a cellie who overhears something that a witness or the suspect say, they don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So that's, and I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony for obvious reasons.
Let me spin a hypothetical here related to the facts of this
Here he
case,
goes,
but
here he
not
goes.
from the facts of this case to make sure I understand your position. So
I
it
love his
sounds like
analogies.
if somebody heard
like Katie,
Kouri or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some kind of deal. And then they relate that Kouri Richins once upon a time in 2022, in January 2022,
made a sandwich.
asked me for fentanyl. And I'm willing to testify to that effect. But if I do that, is that the kind of situation you're referring to?
If we alter that just a little bit, the defendant, whoever it is, told me something, that they killed somebody or
Right.
they shot the gun or
Yeah.
whatever. That I think is different. That's not a witness to the crime. I think if the witness had said the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position. Ms. Nestor.
We have no objection to the new informant instruction or to the making the immunity instruction just general. We're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that.
I heard
Mr.
things.
Burmester is taking the position that as a matter
What
of
did
law,
you hear?
it's
I heard
inappropriate
things.
to give an informant instruction because, if I understand him correctly, Ms. Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants. Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. There are people that gave information and got a deal out of it, whether I just have never seen that distinction made in the past. So I'm not sure I understand his distinction. But the reason I think you need both is because the immunity instruction only deals with the motivation of the grant of immunity. The informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts to Mr. Maynard instead of having to get, urine tests,
Travel to Nevada.
to make herself feel better because she feels guilty. All of that is not covered by, and those are all benefits to her from providing information that can cause a reason to be suspicious. So I think they're both necessary. That's all.
I understand your position. May I ask a different question? I don't understand the relationship between the first sentence and the last sentence of these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this. But
I don't get it. I'm not feeling it. Read it
That
to
is
us. Which instruction?
The last sentence is dealing with the scenario where they find no other reason to find guilt
Right.
other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony in a form alone. Well, if you believe it beyond a reasonable doubt, that's what they're saying. They're saying that you can't. If there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauper's testimony alone.
No,
You'd
they
have to-
certainly can.
You'd have to add some
Right.
language to that statement.
Correct. Absolutely.
All right.
Absolutely.
Anything further, Ms. Nestor?
No, sir.
Okay. All right. Counsel,
Hmm.
with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled Informant
There you
that
go.
comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled Immunity, which is on page 2 here, based on that ruling, the court will not be giving any version of model Utah jury instruction CR 415.
15. Yeah, that's when I was reading. That's why I couldn't
Burmester, any
find that
further
language.
record there?
No, Your Honor.
Okay.
That's their in custody informant.
Then, if you would please turn to page 3. This is a revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone? Ms. Nestor.
No, I think you cured that when it happened, and I think bringing it up now would just bring unnecessary attention to it.
Okay. Any objection to that, Mr. Burmester?
No.
All right. And then, Mr. Burmester, if you look at the 1, 2, 3rd paragraph, I've added some, though not all, of the alternative purposes from Rule 404B. I've added the ones that I think have at least minimal a factual foundation in this evidentiary record. Any objections, sir?
No, that was our request.
Okay. Ms. Nestor, any further record there?
No, Your Honor.
Okay. Very good. Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together.
I heard things.
What things you heard?
All right. Bear with me for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3, under one or more of the following circumstances.
Here we go.
And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay.
Damn
Then
it.
if you turn the
Still didn't-
page, I needed to put the modifier attempted to before intentionally or knowingly cause the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes,
Okay.
I believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Okay.
There's italics on the last couple paragraphs. Is that for a purpose or?
It was supposed to be beyond, no, that is something I just need to edit to match the original. I know what you're going to say. Say circumstance or circumstance is on page 5.
Also, I just caught by looking at that on page 4, the one before,
Mhm.
it should say listed in element 3.
Correct.
He
I
said
made
that.
that,
He said that.
Did you catch that?
interlineation. I
He
did.
did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6.
Okay.
Elements of insurance fraud, count 3.
All right, here we go.
Ms. Nestor, I understand defendant's argument.
And I reject
Based
it.
upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to commit this crime.
Yes.
This is a starting point, a proposal. I'm not the state's lawyer. I just put something in there, get the conversation started.
Nice. Thank you, Your Honor. Very thoughtful. Very thoughtful.
Things.
What things you heard?
So I'll let them talk first because I'm interested to hear what they say.
Other than Richins
Yeah, got it.
spelling,
No
I-
objection.
I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money is
Receiving the money, no.
fraudulent.
Because in the state's theory, and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio was
Because of the forged name.
because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the claim, took the claim. Now, count 5 is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my
Do
concern.
I have that right, Mr. Permister?
Yeah, sure.
Mike,
It's just
go ahead.
like frequently there is when you have a forgery, there's a corresponding count, like a
Right.
theft or
Right.
theft by deception, whatever.
So the only issue I have, I have some issues with that, but the testimony of the True Stage lady, I'm so sorry, I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
Sand coats.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say,
Did you
is this
sign
your
this?
signature? Is this okay with you? That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself, clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
That's why we love Runkle.
So
I mean, I'm saying right. When I say right, I'm saying I understand what you're
I
saying.
think that's what they're talking
Right.
about. Runkle does that kind of stuff for his goals.
So
Oh,
I don't
oh.
understand how
I was like, oh yeah, thanks. That's nice of Runkle.
If if the claim on the death is based on a death that actually happened and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or not,
but I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
you can purchase insurance and put yourself as a beneficiary on behalf of someone. Like I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you can't forge his signature on it.
Unless he tells
Well,
you.
if she had authority to forge his, if she had authority to sign his signature,
But that's a big if. That's in factual dispute in this case. We're just talking about legal elements here.
She's got to keep thinking this out because I don't know about the claim.
Sounds like this will figure prominently in defendant's closing argument.
yeah, I guess so.
It's like
Okay.
you figure it out.
Mr. Burmester, any
And why isn't Lewis chiming in?
Any
Wait, before
She's
we
not
go,
there.
I just want to clarify. So
She's
I
on.
can argue.
Oh, on the Zoom?
I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue. This may be their theory, but we don't think any of this is a crime.
you can say exactly that.
Okay, just making sure.
You can say the state had this theory and didn't prove any of it.
Okay.
No, that's not what she
And it
said.
does start with the state's theory.
Right.
I just feel like you're
Things you
telling
heard
them
on
in an
everything.
instruction that that's a crime. And that's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is, in my mind, you tell me if there's a more artful way to do it in your
Right.
view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts. The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
But it has to,
Well, can we
the
put
act
what our
still needs to
theory
be
is? I mean,
illegal.
I just don't
But you don't have any burden.
know, but we are entitled to theory of defense instructions. I mean, if you're going to put their theory in, I just think adding that part on the bottom is problematic for a lot of reasons. I think just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr. Burmester, any objection?
No.
Okay. I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position
I'm not, exactly. I was
where,
just going to
where
say
they
it.
could convict her for just thought.
Thinking.
Well, we were probably
crime.
in that position by virtue of the Utah legislature when we walked in here today. So I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
So
Whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
absolutely. And I think the
Her
only
point
thing
is,
that
is this even a crime?
did to help it, I mean, because we're not arguing that a bad thought came into her head.
I
That won't
understand.
be argued. But it does help us distinguish unanimity between 3 and 4.
What,
That's the
Well,
one.
I think also the dates.
The
do
dates
that
are
for you.
different.
Yeah.
Absolutely.
what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted a scheme or artifice?
You got to talk to Mr. Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Oh, I see what you're saying.
Now, you can stipulate it to that if you want to create some appellate insurance. But I also take Mr. Burmester's point seriously, and I'm not a appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I think what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
Right.
the evidentiary foundation and the state's closing argument will make it clear that they are alleging that there were multiple acts committed here.
Okay.
Is that fairly stated, Mr.
Yes. We are definitely not making the argument that somehow the instruction is improper or unlawful.
Okay, so just to kind of make clear what happened here is the defense said the statute makes it seem there is no actus reus, there is no specific act, conduct that someone has to engage in per the language of the statute, because it says she devised a scheme. So the judge was like, you're right, that's an issue. So how about we just say exactly what the state is alleging, that she filled out an application, that she did this, that she didn't. And the defense was like, wait a minute, no. That kind of seems like you're telling the jury that if they prove this, they've proved the crime. And I don't want that to happen. So he's like, I'll take it out. She says, okay, please take it out. And then she's like, but wait a minute, now that it's gone, there's still no actus reus in the definition. And I think their point is well taken, that this is a problem. It's a problem legislation created by not wording the crime right. But the state is going to argue that she acted to commit this crime and didn't just think about it. So even though the instruction, I think what she said is right. It should say enacted, that she devised and enacted a plan. And the judge is like, well, I can't put another element that doesn't exist. However, an actus reus must exist for it to be a crime. So I think he probably should have just added the word enacted, and the state probably should have agreed, since they are saying she enacted a plan, and then they wouldn't have a possible potential appellate issue.
Okay. Okay. And then anything else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I didn't make any changes.
You left it the same. Got it.
There were no objections to count 4.
Wait, I thought count 4 was the one.
Did I miss some? I apologize.
Yeah.
Let me take a look.
Let me check.
I don't have any handwriting on count 4.
Just a moment. Okay, let's see. There's one. Just a sec. 2.
Mine is clean as well.
1 and 2. Just a moment, Your Honor. I'm so sorry. Count 4 was the one about the fees. Wasn't that count 4? Or was that count 3?
Count 3 was the language from the statute
that had the
regarding
fees.
fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay.
Your Honor,
Take
I
a
need
look
to
at
go
count
to the
5 for me. Let me know if you have any concerns.
Go to the bathroom. Your Honor, I need to go to the bathroom.
Not from the defense.
I did that for Mrs.
No
Peeve.
objections.
Okay, great.
Pev.
I think you heard.
All right. I think that only, oh no, before we get to spoliation, Ms. Nestor, my apologies.
Oh, spoliation. That's right.
Did I hand out the special?
All right, so we're dealing with the missing
Everything.
fentanyl, untested fentanyl bottle.
Did you, the amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
And
Oh.
we are live.
Oh,
So I played the sound because Mrs. Pev said, I have thoroughly enjoyed watching this case with you. I have to go to the bathroom. Makes me laugh out loud every time. Ha 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 ha. So funny.
so funny. Thank you, Mrs. Pev.
And Rochelle says,
Counsel, we're back on the record.
well-
I've just handed you a
we don't see you,
revised
Judge.
version of the verdict form. If you would just read through it and make sure I didn't miss anything.
So Rochelle says, I know someone who died of fentanyl. It was unknowingly mixed in a substance. Yes. We know people as well.
No, spoilation. Spoilation.
Spoil. SPOIL.
Spoilation in this context is when evidence has been destroyed.
I.e., the prescription bottle.
Missing pill bottle.
Yep.
Where's that pill bottle? I don't know. I heard things.
Iceman comes
you
back
hear?
and says, I know you guys say the jury instructions are boring, but I have been thoroughly intrigued today by this as well as your analysis. Well, thank you, Iceman.
Thanks, Iceman.
What things you heard?
No
Does anybody know what
objections.
movie that's from? Anybody? Anybody?
I mean, it sounds like Cousin Vinny, but I can't even hear it.
You can't hear the sound clip?
Not
No
really.
objections.
Very good.
Son of a
Okay.
blanky. All right, here.
Ms. Nestor,
What things you heard?
I have a list of
What things you
practical
heard?
things I need to talk
Good
about.
fellows.
But did you want to talk any more about
No?
spoliation sitting here today?
No.
Yes,
Go ahead.
thank you. Your Honor, may I remain seated?
Yes.
Thank you.
Nailed it.
Oh, somebody said that
So-
earlier. They must have heard it playing.
The court has
Nailed it.
heard in the trial that the night or the early morning that Eric Richins was discovered
Dirty
deceased in the bed,
Rich,
there
spoilation
was
argument.
a long expired pill bottle directly next to him on the nightstand. The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1000% positive of that, but I think that's what the exhibit number
Kouri.
is. If you look at the picture, you can see there is detritus or whatever the word is, residue. I'll use an easier word.
Dust.
Residue, dust at the bottom of the pill bottle. There was video or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand. And then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1000% sure about that either. But one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony, was sent with the body to the,
In the body bag, right?
I believe so.
To the office of the medical examiner.
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer O'Driscoll, was asked if they were able to, or still had the pill bottle. And his answer was that they no longer had the pill bottle.
I don't think
Did
that
Detective
last.
O'Driscoll say that?
No,
Yes.
it was objected to because it was hearsay. is my
I don't know
recollection.
whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have, they don't, like the Summit County Sheriffs don't have it.
Correct.
Right.
Yeah.
So I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
Not that bottle, no.
Okay.
No.
Meaning no affirmative evidence, or they don't have that bottle?
they
No
don't.
affirmative evidence of this bottle being present or not present.
That's my recollection. I have not rewatched every day of that testimony from the medical examiner.
Well, I do know
Yes.
that the young woman, and I apologize, I cannot remember her name either. I'm just blanking right now.
Dr. Ulmer?
No. The
Ms.
lady
Gibson?
who checked in the body that
Oh.
had the tag, the red
Yeah.
tag on it.
Right.
She testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure. So I know that she did. My recollection is that she testified it arrived at their office with his personal items. I don't know that we've ever had any testimony to why it was lost or destroyed or what happened to it. It's clearly it's gone because it would have been here if it wasn't. So,
But yeah, I mean, let's come back to spoliation, right? You have to first show a violation or that a duty to preserve
right,
existed.
exactly,
Then you have to show a violation.
right,
Then you have to show prejudice.
right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body. So
Well-
who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
It is
Well,
now.
we can do affidavit. I mean, we can do affidavits as to that.
The evidentiary record for trial is closed.
No, for your evaluation purpose for the. I
Spoliation.
mean, it's not. I don't think your finding is based on what happened in trial.
No, but
I mean, because
I mean,
all the time on
the
TV
evidence is closed. Closings are happening Monday. To the extent you were a party wanted to make an additional evidentiary showing and have the court make findings sufficient to
It's only relevant at closing.
support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing
This
that.
is not bad.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to an
Did you ask for it in writing?
submit it to a expert or have it or use it at all, right? So it's missing. There's no question there's a duty to preserve it. I mean, they thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve. We do not have, and I will concede it up front, we certainly don't have any evidence that suggests they intentionally destroyed it. I mean, we've just not come across that in any way. But there's definitely going to be some gross negligence here
Yes.
if the main container of potentially illicit drugs of someone who was found dead of illicit drugs is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but
Not-
keep going.
Not right next to the body, there weren't. And, you know, there was an unknown dust on the nightstand right where the pill bottle was, could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy in how to handle that, right? Like one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved. And
Should have
because
done
of
this
that,
pre-trial.
you know, you should assume that it would have been helpful to the defendant. That's the adverse inference instruction under Cronish versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. That may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
I understand that this is a good faith argument, but spoliation requires findings and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and
Right.
prejudice.
Right.
And we don't have that evidentiary showing.
Well,
I'm
we definitely
asking
have
for a
duty.
hearing.
We definitely have that it's material. I think the only thing that's in question is the breach, right? Like if, to what level of culpability was the breach? And we,
Or was it breached at all? I mean,
Right.
there are things such as rule-based
This is a huge
preservation
deal.
schedules
Sure,
that
sure.
absent, for example, your client certainly knew
This was missing.
that the body was
Pre-trial.
taken,
right.
right? She had an opportunity to ask, what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm
Right.
just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying. It puts us in a position where we might have to have, like, if,
A hearing.
And to be clear, you are not limited from making the arguments you just made to me
right.
Closing.
to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay.
Can we tell the jury to come in at
If
11?
we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed-minded.
Thank you, Your Honor. Understood.
I'm not making any predictions one way or the other.
Okay.
How the hell are
Mr.
you
Burmester,
getting
anything
that?
else on the record
It's
today?
Friday.
Yes, I just wanted to ask.
evening.
Add a requirement that there be a showing of reasonable probability the lost
would
evidence
help.
would have been
Help.
exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I
You're putting it
I
in a
would
pill
just add
bottle.
that to the argument.
I understand.
One way or another, it's going in a pill bottle.
That
Definitely.
is among the reasons.
And with the
I am
residue on the counter,
proceeding with
sounds exactly like
appropriate
crushed-
caution here,
crushed
given
pill.
the findings
Somebody
that the
did.
court would need to make in any
That's
spoliation.
crazy.
Situation. Alleged spoliation.
Not
situation.
guilty.
Ms. Nestel, you've by proximity asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in, but
After you've resolved all
Who
of
is
this, I
it?
just
Oh.
had a request.
no problem. I'm happy to hear you out in just a second. Okay.
Who?
Anything further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
Does anybody know who just spoke up?
I don't know. He's about to let her talk.
But he said a name. All right. Here we go.
I thought
Sorry.
it said she was going to clear some shit up.
Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So
Fine.
we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that,
Yeah.
Ms. Nestor. All right.
I
I'll
said was
confirm it
that
again and
Katie,
make sure
but
he
I don't-
hasn't changed his
I don't
mind.
think it was.
But if he does, what is the time you want us to?
Whatever you all agree to. I just,
We'll do it.
I'm inclined to order it if you folks want it. But if you've agreed to
Yeah,
proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4:00 yesterday. And I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position. We know what's in now. You can put what's in. And if you want to use some creative little thing that is just for,
Demonstrative purposes.
demonstrative purposes, the other side's not gonna be able to object to that anyway, so
Understood.
we're fine.
Okay. With respect to exhibits, defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger and they're of varying kinds, there may be some back and forth about that while you're all doing your on-reading instructions and closing
Sure.
arguments. And so if Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the
Ms.
state is
Steele
present.
was here trying to talk to,
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help.
Okay, so what I have, I can wait till Monday.
If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also,
Maybe that. So that was the person
we've been trying
back there.
really hard to keep track of what we believe has been admitted, just to have a backup.
Right.
Backup. So if we could just, before the exhibits go back,
Yes.
give us a few minutes to make sure we're all in agreement that that's what should go back. And then, we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that that will take longer than a few minutes and will involve somebody from both sides of the beat, Brittany, after closing is complete.
Perfect, thank you.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
Laptop that cannot
And
access the
we're
internet is
fine,
what they're saying.
Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for.
The jury does.
The
not
jury,
the
but I
defense.
don't want you to waste money on us. You can just put it on box.
And then, notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back
No, they don't
to
go
the
back.
jury, correct? Because
Uh-uh.
they're not in court testimony. They were admitted as exhibits. They're going back.
No,
Correct, Mr. Burmester?
Yes.
no.
I believe so, but I will check with that.
It's supposed to be their
we
own.
were,
what they
there
heard.
weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions. Like,
Right,
for
okay,
example,
good. I was like, just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
a companion transcript.
We did agree to those.
Okay.
The parties did, but I'm panicking if there was accidentally
Oh.
some big transcript that slid back past us that we didn't see.
I don't think so. Brittany
Okay.
just wanted to confirm,
Okay.
based upon the conversation we had in the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she understood the state of affairs.
No, I
If
think
it's been admitted
Yeah.
as an exhibit,
it goes
to the
back.
jury.
Right.
Yeah.
I agree.
Okay. All right. Anything else today?
Should have been
Mr.
admitted as a
Burmester?
demonstrative
No.
exhibit.
Ms. Nestor?
I assume since we're doing so good and we're so far ahead of schedule that you're not putting a timer on our closings.
No.
Okay.
Not putting a timer on the jury either.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
It's pretty amazing. We haven't lost a juror in
They are a
3-week
hardened
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They're just, they need to abide by all the rules in case somebody falls ill, suffers a tragedy during deliberations.
Right.
All right. I appreciate your time and effort this morning, Ms.
morning.
Ms. Nestel. Sure. Happy to listen.
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is we're asking for the victim's family to be able to take that second and even third row during the closing arguments. Of course, nobody can anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly. And there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep just to make sure that they get in. Our request would be that they get the 2nd and 3rd row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for the formal event before 0800.
So I'm just going to sound this out in real time. What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But I can steal some rows back from people that do not have a familiar connection to the case. And so, Chris, it sounds like I could say rows 2 and 3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch the order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important day would be
Certainly neither
on
did
Monday.
I. Yeah.
If those rows are not filled, can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is excluding the rest of the public.
Right.
But let's put it blank. Instead of 1 row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family, 2 and guests, and 2 rows for Eric Richins' family and guests.
Okay, thank you.
Chris, now that I've said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
Yeah.
I imagine that I could ask our media partners to help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richins' family and see if they need that 2nd row. And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an expectation.
Okay.
Will you give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
Oh yeah.
Wow.
Oh yeah.
So that was the victim's advocate who spoke up, like, hey, I got something to say.
Yeah. Yep.
So Shannon said, I swear O'Driscoll was asked about the bottle. He was, but the words came out of Blood Smurf's mouth. And he was like, didn't the medical examiner throw that away? And then when they asked him, do you know what happened to the bottle? He said, yes, because I was told that. And then objection, he wasn't allowed to answer.
Oh boy.
So
Oh boy.
let's see what we got over here.
Did you got any bloopage?
Nope.
Oh,
I just checked.
bloopage.
No bloopage. We
Bloopage.
blooped out. We're blooped out. So
Bloopage.
Embiggening Minds says, what's the process for defendants in custody to get ready for court? Do they have access to their own clothes or a mirror? I think they changed them like right? Like right in the
Yeah, usually the family can bring clothes. If they're not in that position, like we've had clients that have had to use, like the public defender's office sometimes keeps
right.
a bunch
Sometimes
of extra civilian clothes, and we've had our clients had to wear those. But your family can bring you civilian clothes to wear.
I don't think they've got access to a mirror. I don't know.
I mean, I feel like they do.
Okay, maybe they do. We don't know.
I mean, we've certainly seen female defendants come in with makeup on.
Well, that was like one judge I think allowed it. Bless Texas Lolly, my mind right now.
Like, I think Lori Vallow would just take a needle and prick her finger and use the blood for rouge. Oh yeah,
Bailey B,
yeah.
your guess is as good as mine. This is what I was thinking. Why wasn't the bottle not a pretrial evidentiary issue? Let's say the defense is concerned that her fingerprints would also be on that bottle. Maybe they're not pushing for it pre-trial. But now that they know that it's gone, they can be like, oh, we needed that fucking bottle.
Oh, yeah, we needed that.
What is this dissimulation that they lost the bottle? It's like
What
complete
about all the
dissimulation
powder
over
on
there.
the nightstand? Nobody scooped up the powder. I mean, that
I
would've
don't know
been
why they
super
didn't
helpful.
ask about the powder, but if they really wanted that bottle, you would have expected that there would have been I would have filed a discovery motion. Where's the fucking bottle?
Where's the fucking bottle? Where's the powder? Where's the powder that was under the bottle?
Closings on Monday and the period of jury deliberations. First row, as usual, will be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richins' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row will get the second and third. Whichever family and set of guests is entitled to the fifth will get the fifth and fourth. Keep in mind, they're going to switch each day. So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches. Mr. Palmer, court security director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for, unless you want to be the point person, Ms. Nestel, it's up to you.
I can do that just to take the burden off of that.
All right.
Yeah.
Ms. Nestel, on behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? Means you got to be here, somebody from your team and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
Yeah.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily. Okay. All right. Anything else, Ms. Nestel?
No.
Ms.
I
Nestel.
can't imagine Corey's
Mr.
filled
Burns.
2 rows.
Folks, I appreciate your patience.
Seems like
Please
people-
travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted to talk.
Oh boy. All right. We're set. Closings Monday morning. No time limit. They
All right,
can go on.
we did that. All right. Did you get everybody on the wheel?
Everybody is on the wheel.
Did they meet the goal? This is what I need to know. Did they
Oh, yeah.
actually meet the goal?
Oh yeah. Goals.
Really?
Yeah.
Very proud of everybody.
Well, it obviously includes all the Venmos and PayPals and stuff. So
Oh.
I gave love to Kristen had sent out a 10 saying you're awesome on Venmo. Thanks, Ellie and Bob. Had a great time watching the trial with you. Thank you so much, Kristen. You were on the wheel. Our Venmo angel Kim threw us another 25 today. Thank you as always, Kim. We adore you. Thank you so much. Cherie kicked us 10. She's like, I don't want to join on the wheel. I enjoyed watching the trial with you. Here's the deal. If you dono and you happen to win, it is within your purview. It is within your authority to transfer your time on the live with us post-closing to anyone that you'd like to. So you just keep that in mind. There might be somebody out there that wasn't in a position to dono that would love to join us and would probably love to take your spot if you don't want to do it. So just keep that in mind. Kelsey says she wants to be screen time on the wheel. Kelsey, you're on the wheel. Iceman, I got your Venmo as well. It says it's Iceman. And this is for the live and not love. Wow. If you don't get it, I screwed up. There's a typo on the goal. And then the Shugana cleaning line, Sugana. They threw 20 at us on Venmo. You two are the very best. Thanks for all you do. It sounds like a fabulous cleaning line, like maybe for your, I don't know if it's for your house or if it's for your face. Oh, janitorial services. So there you go. So you guys go out and buy your Shugana cleaning line products immediately. Thank you very much. And you're on the wheel. And then Ryan said, can't wait. Ryan's ready.
Wait, because people are starting to drop off. Are we doing the Kelsey Fitzsimmons live and is it already set?
I've set it. I had it set for this evening. I'm thinking we might do it around 11 a.m. tomorrow. Just because we have time to prep for it properly.
Okay. All right.
But it is set. I have portaled everybody to it. We hope you guys will join us. There's a lot to go through. We're going to watch yesterday's hearing, which was a glorious day for Kelsey in a couple of different ways. And we're going to go through whatever pleadings, because that trial's set. That thing's happen, and they're going to start picking a jury in that thing on March 23rd. So, but Ryan had said, can't wait to talk to you guys Monday. I met you in Delphi. Look forward to explaining the defense attorney's pause to rest their case. Fascinating. Now I'm rooting for Ryan. I want to hear this theory. I love theories. Or maybe Ryan just knows. Okay, distracted. I got to add distracted. A late entry. You going to read distracteds?
No, but I'm sorry. Hold on.
I mean, we're definitely going to be covering Kelsey's case, that trial. So we're definitely going to be doing that. All right. Distracted is on there. Okay. I think a Cash App came in too. I'm adding you all so nobody gets stiffed. Okay.
All right. So what am I reading? Let's see. Oh, Kaylee says bets on duration of deliberation. Oh, where did we come out with? Did she do it?
Did she do it? The poll was in your heart of hearts. Did she do it? It came out, obviously, is it 75%? No way. 25%. So
I mean, that's a real credit to our chat that they can distinguish the requirements in a court of law versus their own,
personal
heart.
feelings.
Right.
You guys are champions. Absolute champions.
Thank you,
Champions of due process and fair trial.
Distracted therapist. What's next on the docket? Well,
Kelsey
Fitzsimmons.
Yep. All right, hold on. I'm checking the Cash App. I got to know another one came in. I did get the Cash App. Let's see. There was Dr. Russell's Gasp came through with a delightful $10 Cash App. So grateful for your time. It's always a good time. Thank you so much, Dr. Russell's Gasp. And then JD came through with a $20 Cash App. Love you both. Heart. Love.
Thank
and
you.
Then there were a couple of PayPals that I got to get last but not least.
But they're all on the way. Right?
Miss Rattle came through with a beautiful $10.24 PayPal. I don't know why.
Maybe she's from another country, so it does that.
Yeah, I don't know. And I don't know if there's a message there. I'm not seeing it. It doesn't, I can't. So,
Sorry if we missed a message.
and then Monique came through with a $19.10. So it was 20. So there was a 90 cent transaction fee. And then Mark came through with a $5 PayPal. You guys are all on the wheel.
Thank you, all of you.
We appreciate you all so much. We're excited for whoever wins this thing to hang with us on the live on Monday, post closings, to spill the tea. We're just going to spill.
Don't forget to put up the wheel, though.
I will not forget to put up the wheels. I will put the wheels up.
Okay.
All right, there's the wheels. Let me blow it up.
I love the.
Oh yeah.
Oh yeah.
Oh yeah.
Oh yeah.
Oh yeah. All right. Oh yeah. Oh yeah. All right. Let me make sure. I want to make sure. Okay, there's Monique. I want to make sure I got her on there. All right, y'all. You ready? Get ready for the big music, the big, exciting music. Okay. Round and round it goes. Where it stops, nobody knows.
We don't hear the music this time.
Woo! Wow.
We're not hearing the music. Only you are.
You don't hear the music? Oh, the best.
Oh, Yellow Jacket.
Yellow Jacket. Woo!
Hey.
You wanted to get on too.
We got a
ready.
winner.
She was ready. All right. So one of
All right.
our beautiful, glorious mods and a delightful crank will be joining us on Monday post-closing. You guys are you're gonna absolutely love Yellow Jacket. Brilliant, brilliant gal. She'll have a lot to say, I'm sure. So I'm excited about that. All right, you guys. So be prepared. I hope you all come to our live tomorrow. We're gonna have a big Kelsey Fitzsimmons live. Again, we're gonna watch the hearing, go through some documents that we fell behind on.
And just so everybody knows, I mean, it's out there in the world, I'm sure at this point, but the ex was relieved of his duties today as a fireman. What is it? I forget, suspended or just on administrative leave. He's on leave.
Yeah.
I suspect, breaking into your girlfriend's house while she's in the hospital, not conduct becoming of a fireman.
Yes.
Fireman or cop?
Fireman. Firefighter. Yep.
Conduct unbecoming. Absolutely.
Yep. Sucking, all around suckage.
Yes.
We're gonna have to put you on leave for suckage.
Yes. For being just a horrible human being.
For being a real douche.
I got to get all the cameras out. We wouldn't want people seeing what happened.
Yeah. Shit.
All right, everybody. Enjoy the rest of your Friday.
All right, mods. We love you. We love you so much. All of you, Tracy, all you mods, Kai, Sleuthy, Yellow Jacket, all of you guys are in here. All Eyes was hanging. History and Homicide, thank you so much. And any other mods, and thank you guys for all your hard work during this trial. We really appreciate it. Because it's like we try to have a safe space over here, so that's important to us. And to you guys, our beautiful humans that hang with us day in, day out, we love you so very much, because without you guys, I am quite literally just an old man
sitting around talking to his wife.